Yeah. Happiness and mentioning.
My lord,
Harassment. No infraction. Yeah. So reported from 10%. You want a person to run at 10:30 and edit eventually? This is not done. Wrong.
I'm praying for leave to file an appeal without the certified copy.
When was the order passed, sir?
Order was 11th July, my lord.
When did you apply for certified?
You have applied a subsequently in August. My lord.
When? Why? Then why should we grant you leave?
My lord, because
If you were not prompt enough,
my lord, we have been told, my lord, it will take some time to considerable amount of time to in Siliguri. This is an order against the commercial court at Siliguri. They have issued a true copy. They have issued a true copy.
circuit.
No. Does not have commercial division. My lord.
Of course, circuit is there.
Well, it has been returned from there. It has been returned from there, from
You
Siliguri.
don't know, circuit is very much there. Jalpaiguri circuit is very much there. Sorry.
Well,
Find out. It is there. I spoke with Justice Shampa Sarkar this morning
my lord,
from Jalpaiguri.
very well.
You have wrongly instructed, most probably. Please find out. If it is not there, come back to us.
Well, because the very well.
No question of
Very
because.
Very well.
Yes.
Lords, may I have leave to mention item AD20? My lords, it's the Ramsarup Railway matter. My lords, may I have leave to mention item AD20 of today's list, my lord? It's Ramsarup Railway matter. My lords, I'm being led by Mr. S.N. Mukherjee. The pipeline matter, my lords.
Yes.
Yes, my lords. Mr.
I am
Mukherjee is
for
on
this
his...
point number 1.
My lords,
And we have been given mention notice at 10:26. I told my learned friend I would have died by heart attack in that. He said that is her instruction.
Anyway, what do you want?
My lord,
Adjournment.
My lords, can we fix it today at 2 p.m.? My lords, Mr. Mukherjee is on his last leg of
Bachawat is
submission.
not well, my lord. He's very.
My lords, Mr. Mukherjee can
Mr.
conclude.
Bachawat is unwell, my lord. I am on instruction, my lord. Any day next week, my lord, Tuesday.
My lords, Mr. Mukherjee can conclude his submissions.
Mr. Bachawat is unwell. He should be there.
Not say something.
He should be able to hear what Mr. Mukherjee says.
Any day next week, my lord. Tuesday, my lord. I have no issues, my lord.
Next week, dite parbe time.
Tuesday, my lord. 16th, because it is Tuesday and Thursday, the appeal sides are taken up.
Commercial or non-commercial?
This is non-commercial, my lord.
Tuesday, 3:30.
Grateful and deeply obliged. Okay.
It is bullshit.
May I have my lord time leave to mention a contempt matter, my lord, I had mentioned earlier.
This bench,
Yes, my lord.
give it.
My lord, may it be taken up tomorrow, my lord. It's not listed, my lord.
It's not even listed and you want us to take it up tomorrow?
No, my lord. We had mentioned earlier also, my lord. Any day next week also, my lord, if the matter.
Give it, let it be listed.
Grateful, my lord. Grateful. Grateful, my lord.
Yes, sure.
Item number 1.
Yes.
My lord, I am for the applicant. This is the
The
application.
non-commercial.
This is the application for leave to appeal. My lord, I am
কারণ পৌঁছেনি মানে এটা কি পড়ার জন্য গিয়েছিল? It's leave to appeal.
leave to appeal. My lord, it has been ordered passed on 3rd June 2023. This is the passed by the additional district judge. My lord, I
Yes, what is the order?
My lord, we are the land losers. My lord, we have not made a party in the arbitration proceedings by the additional district magistrate. My lord, what's happened, my lord, kindly appreciate drawing lordship's attention. The order dated, order page number 54, the operating portion of the order, the bottom portion. Here is the case thus disposed of. This order will govern all the cases, namely 2 and 2016, 631 of 2016, and even the other awardees who have
What
not
are you
come to
reading?
arbitration.
What are you reading now?
My lord, we are the land losers. We are not given a chance to offer.
What are you reading?
My lord, reading from the judge order.
Impugned order.
Impugned order.
Which page?
Page 54.
Internal page.
Internal page 21. In the leave petition. Page 20.
Internal page of the order. That can't change with the leave petition or stay petition.
No, my lord. Yeah, same, my lord. I am addressing from the leave petition.
Order dated?
Order dated 3rd June 2023.
সব তো পার্টি
3rd June 2023. Last order passed.
Order of 2023.
Yes.
Challenging now.
Telling my lord, since my lord, we are not the made a party.
Doesn't matter.
And that's why we also, along with the section 5 application.
সেটা করেছে leave to appeal বলছে ওইটা করেছে
Yes. Lord, we are also, my lord, suffering by land losers.
You were not made parties where? Before the learned trial court?
Arbitration, yes, my lord.
Learned trial court?
Yes,
Trial court you were not made parties?
not made party. Even that in the operating portion, it has been indicated, those who are not made the application, they are also entitled to. My lord, kindly appreciate inner page 21. In the bottom portion.
Presently, how many intending appellants are there?
Today, my lord, we are, my lord, 1 minute. My lord, the 61. We are not made a party in the proceedings.
আবার যেটা চেক করেছিল সেটাই ওদের Where does it say in this order that this order will govern other cases?
Yes, inner page 21 of the order. I done lot of attention, my copy. It is in page 21. In bottom portion.
This is not the impugned order.
This is the order.
This is the original award, Mr. Mike.
This is the original award. I am challenging, I beg to appeal to the challenging the award. In the award proceedings, arbitration.
How can you challenge the award before us? You have to go by a section 34 application.
Lord, this we are not we are not made the application. Lord, since my lord, this award has been challenged by the authority concerned. This award has also been challenged by the authority concerned. Lord, things for a moment today,
Are
my
you
lord.
challenging the award or you are supporting the award?
we are also supporting the award as because, my lord, this award has been challenged by the authority. National Highway Authority also made the appeal. হ্যাঁ সেটাই তো বলছি, তার against appeal already হয়েছে তো। ন্যাশনাল হাইওয়ে appeal ঠিক বলেছি আমি। ওই appeal রেফারেন্সটা দিতে হতো, ওই appeal রেফারেন্সটা দিতে হতো।
ফাইনাল অর্ডার এটা
হুম?
ফাইনাল অর্ডার
appeal নাম্বারটা কত? আরবিট্রেশন করে তুমি ভুলভাল বলছো। আরবিট্রেশন এটা কাপড় তার মানে সেইটা এইটার জন্য তো I have the notice. Agreed service. Only the national highway has not received return back, otherwise state has not received.
The National Highway is the
Main authority.
main authority.
Yes, sir. That has
Then
been,
there's no service
that is refused.
refused.
মার্কিং নেই কিছু
No, left. RGS left.
Left and refused is the same.
No, left. Well, it has been left RGS. This is has been endorsed.
Service এই লেখো তো। Service is not complete. Paragraph, let service be effected and fresh affidavit of service be filed in court on the next date. শুধু 15 মিনিট নষ্ট। This is the matter, next Thursday করে দাও। Mr. Maiti, you are fairly
Yes.
senior counsel.
Lord,
What
this-
are you doing?
This has been happened, my lord. This has been returned, my lord. The return, my lord.
Find out who appears for the authority.
Otherwise, the state already received, my lord.
That doesn't matter. State is not the answering respondent in the appeal. Now, Draco next.
Refused তো করেনি। Endorse করে।
না নিলে ওরা দেখ
Yes.
I beg to appear on behalf of the respondents.
Yes.
Fine. Appeal from a section 34 order passed by the Learned City Civil Court, Your Lordship. On the last occasion, Your Lordship had directed us to serve my learned friend the affidavit of service, Your Lordship.
But only a section 5 application has been
Section 5.
served, though the memorandum of appeal has not been served.
That, Your Lordship, I'll ensure that it's served.
Your 34 has been dismissed,
My 34 has been dismissed.
but you have a section 5
We
here.
have a section 5, Your Lordship. There's a 54-day delay.
54 days delay will condone, sir. Let us come to the merits.
My lord,
But
maybe
you don't have the papers.
I know, my lord, I have in the soft copies, my lord. I have my papers. The memorandum of appeal I don't have, my lord. The section 5 application I have.
Then how will you?
Your Lordship,
Lordship can condone the delay, my lord. In any event, my lord, this impugned order has been passed on 18th
18th of
March 2024, and the appeal has been filed. It seems from the record that 18th of June. In any event, section 37
does not
subject to
prescribe a
correction.
timeline that I
My
accede
lord,
to. However,
in
Your Lordship,
Borse Brothers, it has been clarified that the specified value, if it is under 3 lakhs of rupees, it will be followed by section article 116 of the Limitation Act. So it is 90 days, my lord. So this application may be not for 54 days, maybe for 1 or 2 days, because it is within the 90 days
it
period.
is within the 90 days period, Your Lordship. Just out of caution, I presume my Lord
Lordship can condone the delay, my lord, will not stand in their way. my lord.
Your Lordship will just kindly take up page number 21 onwards.
OP did not appear, but before the trial court.
No. No.
What is wrong with the order, Mr.
No,
Chakravarti?
Lordship, that I will just indicate. There's nothing too much I can say. I will just try
Have
to
you paid back the money?
not paid back the money, Your Lordship.
Then?
That's what my instructions are.
Then
Your Lordship, the only thing is that I will take a point of jurisdiction, Your Lordship, because the appointment of the arbitrator over here, there was a unilateral appointment. I'm also cognizant of the fact that this was a 2012 reference, Your Lordship. This is prior to the Perkins judgment. But, Your Lordship, the point that I'll be urging is that, Your Lordship, the judgment Perkins, although it's subsequent in time, it is a declaration of law, Your Lordship. So it will apply to that point of time, Your Lordship. Because of the unilateral appointment, I'll try and please before Your Lordship.
To the point of time when
How can
2015, before that it is 2012.
so unless
It-
When did the arbitration begin?
Your Lordship, it began on, I'll just indicate to Your Lordship. It was in 2007, Your Lordship. 2007. Because under 34, Your Lordship, the very limited ground I accede to Your Lordship, I will not come. Lordship, the only point of jurisdiction
no,
would
it
take-
cannot apply. Cannot apply.
effectively.
The amendment cannot apply. Section 21 of the amending act
Yes, Your Lordship, I
cannot
because
apply.
that is 2015 onwards. But Your Lordship, the only point that I'm trying to urge, subject to Your Lordship's wisdom, Your Lordship, that in Perkins, Your Lordship, there is no particular date because over here the point is that the discussion on 11.6a, Your Lordship, with respect to appointments, unilateral appointments, the question of bias, Your Lordship. So that point, if I may urge, Your Lordship, I'm not going on the date of amendment.
You did not take that point
I did
before the
not take
learned
that point
arbitrator.
before the learned arbitrator.
You
The
could have taken that
Section
point.
16 was also not that those points I
রেখে দিয়ে লাভ নেই শেষ করে দেয় ব্যাড কেস মিস্টার করে দিবি ছোট্ট করে ডিলেটাকে কন্ডোম করে দেয় which is the delay can one
Can one,
my
can
second
one.
five, Your Lordship. Your Lordship will just kindly appreciate one thing. My learned friend has rightly said that the period would be 90 days. But Your Lordship, the case that is traversed from the Bombay High Court, Your Lordship, over there it has also been considered that the law governing the appeal in general course will apply. So from the city civil court to the High Court, it is 30 days.
we are condoning your delay anyway.
And on 2024, with an application under section 5 of the limitation paying for condonation of delay of 54 days, preferring the extent of these. Full stop. We have taken through the application and we find sufficient grounds have been made for justifying appellant's belated approach to court. Full stop. Being satisfied that the grounds mentioned in paragraph 9 of the petition are sufficient to condone the delay of 54 days by allowing the application for full stop. 24 stands disposed of as a now taken up for consideration.
along with can 2
And
ওই একটা স্টে ফে হবে হ্যাঁ স্টে
in all the since
We did by consent of the parties. They will take a look.
How can that be? Oh, yeah, marriage. Yes. Make sure I have.
Being challenged and award passed by the on 11/20/13. Ultimately, the faculty paid for petitioner that is keeping in view narrow scope of section 34 of the Arbitration and Conciliation Act 1990. The only point which he feels is arguable in this case is that the arbitrator had been appointed by finance respondent hearing, and that leads to passed by the arbitrator penalty in view of the provisions of section 12.6, 12.5.
12, I'll just 12.5, 12.5.
That although section 12.5 was inserted by way of an amendment in the year 2015, by way of the judgment of the Honorable Supreme Court, in the case of Perkins, what is the citation?
You'll actually the citation 2019. AIR 2020, Supreme Court, page number 59.
Whereby court declared the law inefficiency of the efficiency of the composition or the by finance, that is the respondent here, with one of the parties to the arbitration. Visit the arbitrator and would render the award penalty. That is the only but arbitration whereby not thereby providing that notwithstanding any prior agreement with the person with the party or counsel or the subject matter dispute falls under any of the categories specified in the 7th schedule shall be ineligible. Provided that parties may come subsequent to disputes having arisen between them comma, waive the applicability of this subsection and express agreement in writing.
The arbitrator
Ram
one of the
Comes within the 7th schedule.
comes with-
He comes with the 7th schedule. Okay. Well, it's just not unilateral rule as he 7th schedule. As we want to know. সেটাই জিজ্ঞেস করে।
Ram Pravesh.
ওখানে যেখানে
No, no personal.
submission ওখানে একটা রেকর্ড করে দিন। It is submitted that operator who decided the reference is hit by the provisions of the 7th schedule of section 12 of the Arbitration and Conciliation Act 1996, often referred to in section 12. Referred to in section 12 of the Arbitration and Conciliation Act 1997. আমাদের it is noted from the Amendment Act of 2015 that the provision that is section 5 was inserted in subsection 12 with retroactive effect from October 23, 2015. It is thus evident that the provision was not there in the statute at all at the time when the award, which was impugned before the city civil court, was passed by the sole arbitrator. Full stop. In such view of the matter, the argument of Mr. Chakraborty, too attractive, does not hold ground. Full stop. Paragraph.
Perkins, the case.
Your Lordship, may I hand over a copy? Your Lordship, that
Yes.
One is enough. One is enough. Don't worry. Do that. Do that.
Perkins Sutra is evidently a case where the contract itself was entered into on May 22nd, May 22, 2017, and an arbitrator was appointed in terms thereof. Full stop. The case is evidently not applicable to acts. If you do not find any ground. Furthermore, at this point, it was never reached before the arbitrator. And it was not even a point that came for consideration. Point was not even. This point was also not taken in section 54 code. Of the above, we find an infirmity. The order impugned dated March 18, 2020. FME 3 of 2024 along with and 2. FME 2 to 2024 is dismissed and 2 of 2024 stands disposed of accordingly. Also, there shall be no disturbance.
Can we keep this copy?
please, Your Lordship.
Perkins से रेटर दिए दियो पूरा cost.
Kindly, please. Should I furnish Your Lordship
No,
with a
no.
better copy?
No. Just for the cause title and the citation.
Grateful, dear Lordship.
Grateful, my lord.
If you see, it was inserted from
2000
retrospect, so it was not there on the statute.
Lordship, I cannot urge. Grateful, dear Lordship.
Grateful, my lord.
Yeah. Some stuff.
I've heard the registrars.
Appearance, my lord. Here is my affidavit of service.
My lord, I am appearing on behalf of the respondent, my lord. Yesterday evening, I just received this, my lord, petition.
Yes. So you want time?
No, my lord, your lordship, so please, my lord, I can file a opposition to this particular. There is a delay.
Let us see.
Application is
There's a
there. my
delay.
lord.
How much delay?
My lord,
They have stated 125 days delay, my lord, but the order passed in the December 2024, and they have filed in 25 September. There is more than
1 second, sir. 1 second. 117 days, as noted by the stamp reporter. 117 days delay. You know our views. We are very liberal. Let us see the merit. What is there? Ground of impugned order is dated 4th December
my lord.
24.
yes, my lord.
Section 9.
Yes, Section 9, my lord, in the year 2023, they have filed order passed in the year 2024, December. And they have now
Section
filed.
9 dismissed.
My lord.
Arbitration, you have not initiated arbitration.
No, my lord.
My lord, I have referred to the arbitration. I have referred the matter to the arbitration.
When?
My lord, before 33.
Before?
In the year 33.
Well, actual fact is that, my lord, in the year 2023, they have issued a notice referring the matter to.
Section 21 notice was issued by you.
My lord.
When?
My lord, that is in the.
Where is your arbitration clause?
My
Which
lord,
page?
in the development agreement, my lord, it is annexed to it. Annexed to the application for injunction,
Yes.
my lord.
Tell us the page number, sir.
My lord. My lord, just give me a minute, my lord.
My lord, page 35.
Running page 35, my lord,
Stay application.
of the stay application, running page 35, paragraph.
Stay is can 2 or can 1?
Can 2. Can 1.
Can 1.
Can 1.
Can 1.
Can 2. Can 2. Time, be letter.
But can 1 running page 35, clause 5. Page 45.
45. Named a chena.
35. My lord, it is page 35.
Sir, 45 in our copy.
I'm extremely sorry, madam.
You issued a section 21 notice. What is the date of the notice? And where is the notice?
My lord.
You also don't know what is the date of the.
My lord, actually, there are some shuffling of papers, my lord. That's why that is problematic, my lord. I have received it. It was not annexed, I think, my lord.
My lord, page 75, my lord.
75.
It is 15 September 23.
Ronita Mukherjee. So you called upon them to agree to the name of the arbitrator, Ronita Mukherjee Bhattacharjee. They did not agree. Did they respond to this notice at all?
No, my lord.
Yes,
No.
my lord. Yes, my lord. We have responded. We have issued a notice.
Very well. You did not agree.
Yes.
What did you say? You named somebody else? No. You did not take any steps after that
My lord, thereafter I filed section 9 application.
regarding appointment of arbitrator.
No, my lord. No, my lord.
Then why should the section 9 come to your aid?
My lord,
You have no intention of going to arbitration?
no, my lord, I was in threat. I was in threat.
Those are not. Did you file FIR?
No, my lord, I was in threat that the property will be sold by them. For that reason, I have filed that application under section 9. And my lord knows better than me that section 9 application can be filed even before the arbitration.
My lord, may I submit one thing, my lord?
No, we have not asked you.
দেখুন, জজ সাহেব কি বলছে আগে দেখুন। না, it's okay, sir. কোনো ব্যাপার না। কোনো ব্যাপার না। না, ঠিক আছে।
আবার এটা বলা উচিত হয়।
ঠিক আছে।
তুমি বলে ফেলছি।
না,
Arbitration.
দিয়ে দাও, দেখো, নাই তো। দিয়ে দাও।
You can, you can. You want to say anything more?
My lord, the property is under threat. My lord, they want to sell it out.
Sir, you should have filed a section 11 for appointment
My
of
lord-
arbitrator.
My lord, I shall file it.
No, you shall file it. Is do that, file, and then come back or go before
My
the
lord,
arbitrator.
During
You
that
did
during that time, my lord, the
Ah.
property may be protected, my lord.
may go.
My lord, property may be
Your
protected.
injunction was refused in November 2024 at interim
My lord,
injunction.
my lord.
23.
No, my lord, 24.
23.
23.
No, my lord, 24. December 24.
Impugned order records. Your case was miscase of 23, yes. Miscase 267 of 2023.
That's wrong. That's wrong, my lord.
That's wrong.
Another suit was filed against the landlord for induction of the tenant. Against induction of tenant, that suit was filed title suit. That is not this one.
No, my lord.
Your application that was dismissed by the trial court was under section 9 of the Arbitration Act.
My lord.
Okay.
My lord, identity was refused on 23.
Yes, that's what.
Right.
What's did you challenge that?
My lord, thereafter, as I was so caused, I have filed served the notice upon them. They appeared and they contested the matter. Ultimately, it was December.
Your show cause was rejected, and section 9 was
My lord,
dismissed.
my lord, there are two parts. My lord, if your lordship will be pleased to see the order itself,
Yes.
impugned order.
That my lord, if it was so that the suit shall not be proceeded again, as so cause was not in satisfaction of the learned court, that is one thing. But entire agreement was cancelled.
How can it be?
That is all.
My lord will be pleased to take the order itself in the first page of the order, last paragraph, my lord. It appears, it comes out from the record that it is a case under Section 9 of the Arbitration and Conciliation Act, and an interim order of injunction was refused by order number such and such, and from the said order as well as from the said development agreement, it comes out that the development agreement, it is clearly mentioned in Article 15 that after demise of Asim Kumar, the original owner, the agreement shall stand cancelled, and in the meantime, he died. Moreover, as per the submission of the learned advocate of the respondents, no arbitration proceedings has been filed till date. Under such circumstances, I must consent to observe that this case has now no leg to stand upon. Accordingly, it is ordered that the miscase number such and such is dismissed on contest being infructuous. My lord, if your lordship will be pleased to take the development agreement itself, what is the clause 15 here?
We need not go into that. The fact that you took no steps for initiation of arbitration, accepting issuance of a notice under Section 21.
My lord, for a moment, my lord,
enough.
For a moment, if your lordship will be pleased to take the development agreement, for a moment, clause 15, what it says.
Which page? Clause 15 to মিলবে না তো আবার।
আগে চলে যাও।
Yes, Article 15.
My lord will be pleased also to take the page number 12, that is Annexure B. Annexure B, page 12, where from the agreement for development starts. My lord, here Asim Kumar was the owner first part, second part, third part. And third part as the confirming part is the respondents before your lordship. My lord, they were aware about the development agreement. After the development agreement, I have invested a huge sum of money. I made the building sanction plan sanction, building plan sanction. My lord, now, if your lordship come to page 20, my lord, article running page 31, my lord, running page 31, article 15.
Yes.
The confirming party hereto jointly and severally shall hereby declare and undertake with the developer hereto shall provide all and uninterrupted cooperation to the developer or its assignee for the purpose of completion of new G+3 story building, even after demise. It will be demise. It will be even after demise. It is spelling mistake, denies. Even after demise of Asim Kumar, his wife, daughter, and son, respectively, the confirming party not shall comply all terms and conditions as appended herein before, strictly without any breach, and shall render all sorts of cooperation. আসছে My lord, on the death of Asim Kumar, the power of attorney can be cancelled. It stood cancelled. That's why I have requested the present respondents, the legal heirs of Asim Kumar, to execute a fresh power of attorney so that the building can be completed.
Without wasting more time, you please see that arbitrator is appointed. You can always obtain interim order from the arbitral tribunal.
Right.
This issue.
My lord, one thing, may I submit, my lord?
No, why? We are not allowing this appeal. Why will you submit? This appeal is directed against an order dated December 4, 2024, passed by the learned district judge, Howrah, in miss case number 267 of 2023, being an application under section 9 of the Arbitration and Conciliation Act, 1996, filed by the appellants
Appellates, my lord.
appellants herein. Stop. Paragraph. It appears that there was a development agreement to which the appellants and the respondents were parties. Stop. The agreement contained an arbitration clause for resolution of possible disputes and differences between the parties. Stop. Paragraph. It appears that disputes arose between the parties and the appellants herein approached the learned trial court with an application under section 9 of the 1996 Act, praying for interim reliefs. Stop. Paragraph. From the order impugned, it appears that that on August 30, 2024, the appellants were absent before the learned trial court. Stop. On that date, an order was passed by the learned trial court directing the appellants to show cause on November 7, 2024, as to why the Section 9 application should not be dismissed. Stop. Paragraph. On December 4, 2024, i.e., the date of dismissal of the Section 9 application, the appellants filed a show cause petition. Oh, I see. হ্যাঁ, কিন্তু 4th December ফাইল করলো এক্সপ্লেনিং কেন 7-11 করে কারেক্ট, কিন্তু এই আগেরটা যেটা চেয়েছিল শো কজ যে তুমি কেন অগস্ট 30 অ্যাপিয়ার করবে সেটা করেইনি। কারেক্ট। কি বললাম? কি আচ্ছা, তার আগে একটা লিখে দাও। On November 7, 2024 also, the appellants herein did not appear before the learned trial court. Paragraph. তারপরে যেটা বলছিলাম, on December 4, 2024, i.e., the date of dismissal of the Section 9 application, the appellants filed a show cause petition seeking to explain why they could not appear before the learned trial court on November 7, 2024. Stop. There was no explanation for their absence on August 30, 2024. Stop. The learned trial judge observed that the show cause filed by the petitioners is not satisfactory and the same was rejected. Stop. In the said background, the impugned order was passed, the operative portion whereof reads as follows. এই মেমো থেকে বুঝেছো করে দিচ্ছি, মার্ক করে দিচ্ছি, এটুকু দিয়ে দিলেই হবে। Dismissed. Paragraph. Being aggrieved, the petitioners before the learned trial court have Being aggrieved, the petitioners before the learned trial court have come up by way of this appeal. Paragraph. We have heard learned counsel for the parties. Stop. Paragraph. It appears that a notice under Section 21 of the Arbitration and Conciliation Act, 1996, was issued by the present appellants in September 2023. 9 September, what September? 15 September. On 15 September. On September 15, 2023, calling upon the respondents herein to agree to the name of an arbitrator suggested by the appellants herein. Stop. The respondents did not agree to that name. Stop. The appellants herein did not take any further step for appointment of arbitrator. Stop. Instead, they approached the learned trial court with the Section 9 application. Stop. Their prayer for ex parte ad interim order was refused by an order dated November 23, 2023. Stop. The appellants did not challenge that order also before any higher forum. Stop. Thereafter, the appellants defaulted in appearing before the learned trial court on at least two occasions. Stop. They could not explain sufficiently or at all as to why they were absent. Stop. Paragraph. The learned trial judge rejected the explanation sought to be furnished by the appellants. Stop. The learned judge also noted that the appellants herein have not taken requisite steps for appointment of arbitrator. Stop. Accordingly, the Section 9 application was dismissed. Paragraph. We see no apparent infirmity in the order under appeal. Stop. After issuing the notice dated September 15, 2023, ostensibly under Section 15 of the Section 21 of the 1996 Act, and finding that the respondents did not agree to the name of the arbitrator suggested by them, the appellants ought to have approached the concerned court with an application. Concerned court means the High Court. To have approached the High Court with an application under Section 11 of the 1996 Act for appointment of arbitrators. Stop. The appellants did not do so. Stop. Even today, there is no such initiative on the part of the appellants. Stop. Therefore, the conduct of the appellants does not show that they are seriously interested in initiating arbitration proceedings. Stop. If that be so, no relief under Section 9 can be granted to them. Stop. Paragraph. The appeal and the connected application are accordingly delay আছে নাকি? ওইটা তাহলে একটা ডিলেটার নিয়ে আগে কন্ডোন করে দিও, causes shown being sufficient. The appeal and the connected application are dismissed. Stop. This will not prevent the appellants from taking recourse to Section 11 of the 1996 Act and also to Section 17 of the 1996 Act after constitution of an arbitral tribunal. 17 is out. Stop. This order will also not prevent the কিন্তু এটা বলা ঠিক হবে না, না যা বলা হলো ঠিক আছে। We only clarify that if the appellants file any other proceedings in connection with the development agreement before any other forum, such proceedings will be decided by that forum without being influenced by any observation in this order.
Good. With the lordship, please.
My lord, I'm for the appellant, my lord. In my case, my lord, a section 9 order has been passed not in our presence, that is ex parte, when the intimation was even not served to us. The order was passed on, my lord, 8th of August 2025, and the appellant was informed by a WhatsApp message that an order has been passed. That's it. And then again, she all the way came from Coimbatore to Kolkata, and we found on 27th of August, we put up the case and found that the order has been passed. We got the certified copies.
How have you filed your papers? It's upside down.
Mila, should I mention the running page? Better I mention the stay petition. I have filed a stay petition also.
19th November is the next date.
Yes.
They have taken possession already.
No. They have sent us a notice that they will take possession on 5th of September. Before that, we filed this case and intimated the other side. And not yet they have taken the possession. And my letter here, I'm just annexing the letter here.
You have paid only 14 installments out of 48.
That loan was issued from 2024. Until date, it is 16 installments. I have paid 16 installments. I will show everything in have showed in the stay petition.
Why don't you approach the learned trial court? Go there. Ask for vacating of this order.
My lord,
The order was passed ex parte. Go there. Why are you wasting your time here, madam?
Because on 5th, it was they were to take the possession and my business will be paralyzed then, my lord.
No, what can be done? You should have approached for vacating once you came to know of the order. It was an ex parte order. You should have gone there and said why the order should be vacated.
We will be submitting the whole WS has been done already.
Go there, go there.
May not the stay be passed with that, or else they may take the repossession. Because there was no arbitration section 11 approached, my lord.
Madam, we'll do this. We'll modify the order. The receiver may take symbolic possession, not remove from their possession now, and you will not deal with the equipment. What is the equipment?
Engineering products.
Engineering products. Excepting in usual course, you may use it for your business purpose, but otherwise, no third party interest, no sale, no mortgage, no hypothecation, nothing. Go approach the learned trial court and fight it out there.
Default is admitted in their petition itself.
Yes, yes.
My lord, I haven't appreciated any default. There is no default from our end, my lord. We have paid all the EMIs.
Yeah.
See, the loan is till 2028, my lord. 48 installments out of, until August is 16th installment. We have paid all those 2 installments.
Settle the matter, madam. Settle the matter with them.
Much okay.
Hey, mediation. Why don't you go for mediation?
That I am also agreeable to, madam.
This appeal is directed against a judgment and order dated August 8, 2025, passed by
It's a city civil court, my lord.
Second bench.
in the office of the city civil court. Passed by the learned second bench, City Civil Court at Calcutta, in Miss Case 10746/25, stop, 25, comma, being an application under Section 9 of the Arbitration and Conciliation Act, 1996, filed by the respondent herein against the appellants. Stop. Paragraph. It appears that there was a financing agreement, hire purchase.
Hire purchase.
Hire purchase.
Hypothecation
Huh?
agreement. Loan cum hypothecation agreement.
Loan cum hypothecation agreement between the parties in respect of certain engineering equipment. Stop. Alleging that the appellants have defaulted in payment of agreed installments, comma, the respondent herein approached the learned trial court for appointment of receiver over the concerned equipment, stop, by the impugned order, comma, the learned trial court has appointed receiver to take actual possession of the concerned equipment, stop. This order was passed ex parte, stop. Upon coming to know of the order, comma, the appellants have come up by way of this appeal. Paragraph. Having heard learned counsel for the parties, we are of the view that there is an element of settlement in the matter. Stop. The parties should try out mediation. Stop. Learned advocates for the parties agree to our suggestion. Stop. Paragraph. We direct the member secretary of the High Court Mediation Committee to appoint appoint a trained mediator to mediate between the parties here to stop. The mediator shall file his report within a month of the first sitting before the learned trial court where the application under Section 9 of the 1996 Act is pending. Right? Stop. Due and sufficient notice of the mediation sittings will be issued to the parties or to their learned advocates. Stop. Paragraph. We dispose of this appeal and the connected application by modifying the order under appeal to the effect that the receiver appointed by the learned trial court may take symbolic possession and not actual physical possession of the concerned equipment. Stop. The appellants are permitted to use the concerned equipment for their business. Stop. However, comma, they are restrained from selling or creating any third-party interest or otherwise dealing with the said equipment without the leave of the learned trial court. Stop. Paragraph. In the event the mediation succeeds, comma, the learned trial court shall pass appropriate final order in terms of the agreement between the parties. Stop. Otherwise, comma, the learned trial court shall decide the Section 9 application in accordance with law upon hearing both parties, comma, without being influenced by any observation in this order. Paragraph. In the event the mediation proceeding does not conclude within the period indicated above, comma, the parties will be at liberty to pray for appropriate orders before the learned trial court.
One more prayer, my lord. In the event mediation fails, my lord, then the respondent will be at liberty to proceed as per the agreement, my lord.
We have said so the trial court will decide the Section 9 application.
Yes, my lord. The arbitration is to be, in the event it does not succeed.
Yes, yes.
Then arbitration is to be initiated, my lord.
Yes, yes. We'll decide the Section 9 application in accordance with law without being influenced. Stop. Needless to say, comma, in that event, comma, the respondent herein shall also be at liberty to initiate arbitration proceedings.
Deeply obliged, my lord. Extremely obliged.
If it may please my lords, my lord, I appear on behalf of the appellant. My lord, I am on appeal, my lord, from,
You're a doctor.
my lord, I am a doctor.
You have purchased a Mercedes.
A Mercedes, however, my lord, with the caveat, a pre-owned Mercedes valued at 14 lakhs, my lord, per the loan sanction. So, my lord, may kindly not think.
Lordship, may I submit, Lordship? I have instruction to appear on behalf of the respondent. Lordship, I have not been served with the copy of the.
My lord, I wish to move ex parte. My lord, I will show. My lord, this order has been obtained ex parte by subterfuge. It is an entirely perverse order without any reasoning. And I will show the conduct, my lord, of the respondent. If I may kindly place it, my lord. My lord, I wish to move ex parte if my lord may kindly allow me.
No, we will not allow you.
My lord, may kindly appreciate.
Serve and come back.
My lord, may
Grateful, Lordship.
very well, very well.
Service has not been effected on the respondent finance company. Stop. Let such service be effected and affidavit of service be filed in court. You accept service. You will accept service on behalf of your client.
Yes, Lordship.
Achha, let such service be effected on learned advocate for the respondent company who enters appearance in court, comma, in course of the day.
Very well.
কবে হবে? Tuesday. For you, a special case tomorrow before original side.
I am deeply grateful. I am deeply grateful. I will just, sir, deeply.
But your Mercedes will go. Unless you pay, your Mercedes will go.
Will indicate. We are a 14 lakh Mercedes.
Doesn't matter.
Grateful.
One defect is there, my lord. Kindly remove this.
Defect? Deficit court fee?
No.
No.
Only minor defect is there, my lord. You will also kindly give me time, my lord.
Defective. ঠিক আছে.
Tomorrow.
Not tomorrow. What is the urgency? Tuesday.
Lordship, I have instructions to appear on behalf of the respondent, Lordship.
Service, he has not affected service.
Actually, there was no caveat. It's coming against an order.
Now that he is appealing, give serve. Acha, leave is granted to learned advocate for the appellant to remove the defect noted by the stamp reporter. Stop. Per paragraph. Let service of the appeal papers be effected on learned advocate for the respondents who enters appearance. Stop. Paragraph. List this matter. Tuesday করে দাও. Oh, this is that trust matter. Trust matter.
This is a trust matter. Section 9 application was moved.
You are the landlord. It's your land.
Yes, their landlordship. Order impugned is not to evict me without due process of law. We have already initiated Section 11. Matter is pending before Lordship Justice Shampar Sarkar as item number 22 in the monthly list. She will be sitting on Monday.
All right.
Item 7.
Petitioner, my lord, there is a defect. Defect, lord, for deficit court fee.
400 rupees.
400. I
Yes.
see, lord. I'm lord, section 5. I have filed the section 5 application.
তুই করবিটা কি করে সময়টা করতে পারবি? তুই তো 90% কাজ তো তুই করিস, আমাকে You remove that effect, pay it in course of the day.
I shall not.
Yeah.
Lord, this section.
You're appearing for the bank.
Yes,
Hey, no, a second. Hey.
This is my service.
Ex parte order.
Ex parte order.
Go before the learned judge. How much is due?
Lord, the kindly come to page 21. That is, Lord, 1,06,734. Lord, the part of the second installment and the third to 8 installment.
Have they taken possession already?
Lord, the receiver is has taken full
Physical possession.
it's already been initiated, my lord.
Arbitration has been initiated. Then what can be done, sir?
Lord, the arbitration, I have not got any notice, Lord,
That is
regarding
my
arbitration.
instruction, my lord. I can.
Lord, neither
No, initiated when you filed section 11 or what?
No, my lord. As per the agreement, my lord.
As per the named arbitrator.
Yes, under section 21, notice was issued, my lord, and
Sir, you better don't waste your time here. This is an ex parte order. Go and apply for vacating. We'll grant you that liberty. Go
Lord,
immediately.
Lord, they kindly put me on any terms and to hand over the vehicles, Lord. Put me on any terms.
How much is due presently?
Lord, they kindly come to page 21, Lord.
my lord, may I come back tomorrow, my lord, with the instruction exact amount, because if I see
Lord,
any amount now, that would
I
not
am
be proper,
indicating
my
from
lord.
their own record, Lord, by page 21, Lord. Kindly see page 21 of this petition.
21.
Yes, Lord, the particular second installment, 6,234.
Oh, this is the section 9.
Section 9, Lord. Their application, third to 8.
9,14,000.
No, they have calculated the area, Lord, the future.
But my lord, that was in June when the
on the
section
day-
9 was filed, my
On
lord.
the day of the institution of the case, Lord, 1,06,734.
By this time, it has already increased.
Correct. That was May 25,
Yes, my lord.
29th
By
May.
that time, it has already been
13,000, Lord, per month EMI, Lord. That will be
1-3.
1,3.
So May, June, July, August, September. 4 more months.
No, it was passed on, Lord. They filed this application in the month of June, Lord. Order impugned was passed in the month of June, 21st June.
Go back, sir. Go back. Offer to pay them that money before the learned trial court.
Lord, kindly
You are
put me-
admittedly in default. We are not inclined to entertain.
Lord, kindly, otherwise, Lord, my property will be, Lord, disposed of by
No,
them.
no, it won't be. That we will make clear that you will be entitled to, and they will not dispose of the property for a certain period.
Yes.
For a certain period.
Lord, kindly put me on terms. I shall pay them to some money, Lord.
Tell the learned trial court that we are granting you that liberty. Esho. Tell the learned trial court that. Go approach. কোথায় গেল মেমোটা?
Lord, the one more point, Lord, the jurisdiction regarding the Lord, the case has been filed in the city civil court. Lord, I will show from their agreement. Lord, the seat of arbitration is at Chennai. Lord, all the cause of action aroused in the district. Lord,
We will leave that point open for you to raise before the learned trial court. Go. This appeal is directed against an order dated June 21, 2025, passed by the learned 12th bench, Judge কোথাকার সিটি সিভিল কোর্ট
city civil court.
কোথাকার 12th bench তার বললো
Lord, I do not find any name of the arbitrator from the agreement.
12th bench, City Civil Court at Calcutta, in Miss Case 7626 of 2025, being an application under Section 9 of the Arbitration and Conciliation Act, 1996, filed by the respondent bank. Top paragraph. It appears that the appellant availed of loan, availed of loan from the respondent bank. They have defaulted in paying agreed installments. Accordingly, the bank approached the this was a loan cum hypothecation again.
Well, it's a loan agreement.
Loan agreement. And this thing was hypothecated to you.
Yes,
The learned trial court with an application under Section 9 of the 1996 Act for appointment of receiver over the equipment which was hypothecated in favor of the bank as security for the loan advanced by the bank to the appellants. By the impugned order which was passed ex parte, by the impugned order which was passed ex parte, the learned trial court appointed a receiver for taking actual physical possession of the vehicle in question. What is this vehicle? Al Bada Dost.
Lord, that is not the commercial vehicles, not the personal vehicles, Lord.
I'm trying to understand what kind of a vehicle. Al Bada Dost.
Lord, I also fail to understand what kind of the vehicles this is, Lord. But I am told this is not the commercial vehicles, this is a personal vehicles.
Vehicle in question. এখানে আগে equipment বলেছিলাম না, ওখানে vehicle করে দিও। Vehicle in question. Stop. We also understand that the receiver has already taken physical possession of the vehicle. Stop. Paragraph. Learned advocate for the appellants says that the appellants may be put on terms and the receiver may be directed to hand back physical possession of the vehicle to the appellants. Stop. Paragraph. We are not inclined to entertain this appeal, as the appellants should ideally be approaching the learned trial court with an application for vacating or modification of the ex parte order. Stop. Admittedly, the appellants are in default. Stop. If they wish to make up for such default and make payment to the respondent bank, they are at liberty to do so before the learned trial court or otherwise. Stop. Paragraph. Learned advocate for the appellants further says that the City Civil Court at Calcutta does not have jurisdiction, territorial jurisdiction, to entertain the Section 9 application. Stop. It will be open to the appellants to urge this point before the learned trial judge. Stop. If this issue is raised, the same should be decided as a preliminary issue by the learned trial court. Stop. Paragraph. We have not gone into the merits of the disputes between the parties. Stop. It will be up to the learned trial court to decide the Section 9 application or any vacating or modification application that may be filed by the appellants herein, in accordance with law, without being influenced by any observation in this order. Stop. Paragraph. We only put on record the submission made on behalf of the respondent bank that arbitration proceedings have already been initiated. Stop. This is disputed by learned advocate for the appellants, who says that the appellants do not have any notice of such proceedings. Paragraph. To enable, to grant a breathing space to the appellants, comma, we restrain the respondent bank from dealing with or disposing of the vehicle of which possession has been taken by the receiver, comma, for a period of 6 weeks from date. Stop. In the meantime, comma, the appellants will be at liberty to obtain appropriate orders from the learned trial court if they can do so.
Lord, kindly direct the learned trial court. In the event I shall file any application for vacating or modification, that shall be decided, Lord, on urgent basis. Otherwise, 6 months,
in the event the appellants file an application for vacating or modification of the ex parte order appointing receiver, comma, the same shall be disposed of as expeditiously as possible, comma, without granting unnecessary adjournments to either of the parties and by fixing short dates. Appeal and application disposed of. Delay, there was delay.
Yeah, there was delay, Lord. Application filed, Lord.
How much?
Lord, that was
35 days, man.
Hey, করে দিও. Which one, can 1 or can 2?
Can 1, Lord.
Can 1 allowed. ওটা করে দিও. Causes shown being sufficient.
Lord, there is also delay, my Lord, the same fact, Lord.
I'm for the respondent, financial institution.
Here also motor car.
Yes, Lord. 80 days delay, Lord.
Delay condone, delay is nothing. And same type of order, you go back. Yeah, if a receiver has taken possession, actual. For 6 weeks, don't dispose of, don't. এটা তো একই order হয় ভাই। Order date টা খালি কবে? May 7, impugned order টা May 7, 25. The second court, it is civil. What is this, Mr. Ganguly, in the office of the city civil court? Look at the order, impugned order, at the top. This is the first time I'm seeing this.
My lord, I will intimate to the learned court below, my lord.
What is this?
I am
What is happening?
aware of this type
What
of...
is happening?
I'll intimate the learned court below, my lord.
This was also a loan cum hypothecation agreement.
Loan agreement and hypothecation.
Same house, hypothecated the vehicle. যা ছিল ওখানে. Same.
May I pray for only one indulgence? The respondent is not against the vehicle. They are interested in money. If they pay, well, in that case,
Do you want to go to mediation, or you want to just sit across the table and try to settle?
Whatever my Lord directs, Lord.
I am let the party sit across the table. I believe the dispute will be sorted out.
Paragraph last day লেখো তো,
Lord,
last.
then kindly send it mediation, because Lord, in the event the client goes there, their office, they will, Lord, charge the entire money. Lord, the loan agreement up to 2030.
Can you go to for mediation?
Yes, ma'am. If you
Yes, go. Paragraph. After this order is dictated, comma, learned advocates for the parties say that they are agreeable to try out mediation for resolving the disputes between them, between the parties, between them. Advocate, there is no dispute between the parties. Stop. Paragraph. Accordingly, comma, The member secretary of the High Court Mediation Committee is directed to appoint a trained mediator to look into the matter. Stop. The due and sufficient notice of the mediation proceedings will be issued to the parties and oblique or to their learned advocates. Stop. The mediator shall file his report before the learned trial court within 30 days from the date of initiation of mediation. Stop. In the event the mediation succeeds, comma, naturally the learned trial court shall record a final order in accordance with the agreement arrived at between the parties. Stop. Otherwise, comma, the learned trial court shall decide the Section 9 application in accordance with law, observing the principles of natural justice. ঠিক আছে? আর ওই 6 weeks যেটা ছিল 6 weeks আছে? ঠিক আছে? In the paragraph, in the event the mediation does not conclude within the period indicated above, comma, the parties would be at liberty to pray for appropriate order before the learned trial court.
Then should I go before the mediator first, or I should file an application for modification before the?
No, now mediator, I think, right? So this first mediator.
Then Lord, kindly direct the mediator to for the first sitting at least within 7 days. Otherwise, Lord, the puja vacation will intervene, Lord.
It is desirable that the first mediation sitting is held within 7 days from the receipt of a copy of this order by the member secretary of the High Court Mediation Committee. Stop. Paragraph. ওই আগেরটাতে বলতে হবে registry. Registry is directed to communicate this order to the member secretary, High Court Mediation Committee. Stop. The learned advocates for the parties shall also be at liberty to communicate this order to the member secretary, High Court Mediation Committee. We আগেও একটা আমরা মিডিয়েশন রেফার করেছি, কে নিয়েছে বলে গেছি 4 নম্বর এইটা বলে দিও কমিউনিকেশনটা। হ্যাঁ,
There is a delay application. Lord, the next one is also the same.
We'll come back in 3 minutes. না, মিডিয়েশন বলছি আদারওয়াইজ করে তারপরে
Lord, I am for the appeal.
But you have been instructed to appeal on behalf of the respondent, Your Lordship. The copy of the appeal has not been served upon us.
Copy দেওয়া হয়েছে। Lord, I have given them. Yes, delivered.
Lordship, then I have to get instructions. As per my instructions, the copy has not been served. Then, at least, Your Lordship, copy has been served. If kindly be served upon us only.
Give him a copy and come back then. What to do?
Lord, the same thing, same.
We understand, but he is not in this. He was not in the previous matter.
I was not in the previous matter. No instructions. Also, they have instituted a title suit. I have been instructed. They have instituted a title suit also before the.
We are only concerned with
Yeah,
this
with the
section 9
only,
application.
but I have to.
Give him a copy, come back tomorrow before the original side. We'll take it up.
Yes, sir.
এই দুটো হবে before original side. একটা ওটা আর এটা।
তাহলে এর নাম্বারটা লিখে দিন।
আমি দিয়ে দিচ্ছি।
Were you here when we dictated the last order?
I was there.
Similar type of order we want to pass. Take instruction. If you are agreeable to go to mediation,
But,
we can modify the order
And there will approach the mediation.
and go for her.
Lord, may I come back at 2 p.m. In the meantime, I shall hand over the
2
copy.
p.m. I'll not get
Ask him.
2 p.m. I'll not be able to.
একটা সময় নেন।
No, 2 p.m. I have some difficulties, Your Lordship.
Tomorrow. We can't
Lord,
wait
then-
till tomorrow.
এখন দিলে আপনি করবেন? আমি এখনই দিয়ে দিচ্ছি।
No, I have to get instructions from my client, sir.
You have difficulty tomorrow.
No, Lord, I will come. Then my lord has to take this order tomorrow, then it will be difficult.
No, this today we'll ensure that it's uploaded to today.
Also, tomorrow I can bring the order also. The order which was passed on the earlier item. I can also bring the order.
পড়ে নিন, আমি দিয়ে দিচ্ছি আপনাকে এখনই।
I have to get
একই তো অর্ডার হবে।
আর আমি instruction দিতে হবে, sir. I have to get instruction.
Come tomorrow, come tomorrow. Oh, that.
Now,
Fresh proceeding. Yes, Mr. Bandhu.
I beg to appear for the.
Seeing you, good to see you.
My lord. I beg to appear for the alleged contempt number 2. One is not relevant for this purpose, my lord. Yes. My lord, my simple prayer is that, my lord, kindly gives us time till the end of November to come back with your lordship, my lord. We are in the process of complying with the order, my lord.
Very well. Mr. Jahan says yes. Who are we to say no?
When he is there, my lord, I will not. Because I know he can do.
If he wants, anything will be done. You are now the senior standing, no?
Yes,
Senior
finally.
standing. Principal Secretary Public PHE.
Yes, my lord. Content number 2, alleged content number 2 is relevant for this
Well,
purpose,
you
my
can
lord.
expunge one.
One, my lord, has come out.
That would be better.
She has no role, my lord. Yes.
She's from a.
He is PWD
PWD.
department, basically.
Pursuant to issue. One is Antara Acharya.
Yes, my lord. She is not relevant
She
for
is
this
also
purpose.
PHE.
No, my lord, she is in PWD actually.
Then this is wrongly stated here.
One may be expunged, my lord.
Pursuant to service, Mr. Shishwarna Bandyopadhyay, learned senior standing counsel, appears for the alleged contempt laws. Paragraph. Mr. Bandyopadhyay says that the alleged contempt number 1 has no connection with the present matter. Stop. She is posted in the Public Works Department of the government, and it has been wrongly stated that she is the Secretary of the Public Health and Engineering Department, Government of West Bengal. Stop. Paragraph. Mr. Jaha, learned advocate appearing for the petitioners, in his usual fairness, says that the name of the alleged contempt number 1 may be expunged from the contempt petition. Stop. We accordingly order expunction of the name of the alleged contempt number 1 from the cause title of the contempt petition. Paragraph. Mr. Bandyopadhyay says that he represents the other alleged contemnor, stop, who is now the sole alleged contemnor, stop. He says that the entire process, as was directed by the order in question, should be completed by the end of November comma 2025. Stop. Paragraph. We therefore propose to list this matter once again in the first week of December, comma 2025. Stop. Mr. Jaha, comma learned advocate for the petitioners, does not have any objection to such proposal. Stop. Paragraph. List this matter once again on contempt though, appellate side, on December 4, comma 2025. Stop. On that date, comma, the alleged contemptor should file an affidavit of compliance.
My lord, may the phrase, my lord, upon instructions be included in my submission, my lord.
Which
The
one?
Bandyopadhyay submits on instructions.
Oh, by the end of November complete hobe. Mr. Bandyopadhyay submits on instruction. We're all creatures of instruction.
Absolutely, my lord. Since I have not produced something in writing, my lord, I had a talk with the principal secretary, my lord.
Very well.
And in terms of 4th September order, I am filing this affidavit of service because I was directed to serve.
Paragraph affidavit affidavit of service filed in court today, we kept with the records.
Great.
Extremely grateful, my lord.
But I beg to appeal with petition. It is also same type of matter. He took some loan and he failed to repay the same money.
Sorry to interrupt. The order impugned is not appealable, my lord.
Oh.
It's against the allowing of Section 8 application by the learned trial court.
But the injunction order was originally granted and subsequently it was rejected, my lord. And on against that application.
What is the date of the order?
My lord,
Order number 11 dated 30th January 2025.
The Section 8 application, sir.
that has been allowed.
But we filed an appeal. We filed an application. Injunction was granted. Subsequently, they filed for vacating that interim order, my lord. And on the basis of that application, the interim order was vacated.
No, that is a separate Section 9
They
application.
filed a suit, my lord. Title suit, my lord, in which
Oh,
we
I see.
appeared and filed application under Section 8.
I see.
And in the meantime, my lord, one development is there, my lord.
It's not an appealable order.
Their Section 8 application has been allowed by the impugned order, staying the suit in effect, referring the disputes to arbitration.
Lordship.
This is not appealable. You have to go for revision. Section 37 does not provide for an appeal against this order. If their Section 8 was rejected, they could have preferred an appeal. Are you following what we are saying? So you better withdraw it, or we'll dismiss this and grant you liberty to approach the appropriate forum.
Better withdraw and liberty to approach the.
Sure. This appeal is directed against an order dated January 30, 2025, passed by learned Judge Bench 10, Bench Roman 10, City Civil Court, Calcutta, on an application filed by the respondent herein, under sections 5 and 8 of the Arbitration and Conciliation Act, 1996, for reference of the disputes between the parties to arbitration by staying the suit that has been filed by the appellant herein. Stop. By the order impugned, the application of the respondent bank has been allowed. Stop. Paragraph. An order allowing an application under Section 8 of the Arbitration and Conciliation Act, 1996, is not appealable, as would be evident from the provisions of Section 37 of the 1996 Act. Paragraph. Hence, as requested by learned advocate for the appellant, we permit the appellant to withdraw this application with liberty to approach the appropriate forum. Paragraph FMA such and such is dismissed as withdrawn. Stop. Let the certified copy. Have you filed the certified copy?
Yes, Lordship.
Of the order impugned be returned to learned advocate on record for the appellant upon a true copy of the said order being furnished for being kept with the records. Give a true copy, give a photocopy, and take back the certified copy. Hey, you know?
Obliged, Lordship.
Well, I appear for the appellant.
My lord, I'm for the respondent, my lord.
My lord, here, my lord, had
Filing the affidavit in opposition, my lord, to the supplementary affidavit filed by the.
there was no liberty granted, perhaps, but I don't stand in the way. Let them file it. I'll rely upon a paragraph of their own affidavit in opposition. Though, my lord, there was no direction for affidavits to be exchanged. They've served us a copy as well. It doesn't really hurt my case, my lord. I'll indicate.
I got an instruction as per he appeared the last timing. Oh, acha. Yes, sir.
Order কি affidavit opposition কি action তো ছিল না। ঠিক আছে।
मैं पूछती हूँ।
My lord, will recall this is an appeal arising out of an order, my lord, dismissing
You
my
filed
petition.
your section 8 beyond the
Beyond the
period
period.
permitted for filing written statement.
Yes, my lord. Now, two things. That is what the finding of the learned court is. My endeavor will be to show that that finding, firstly, is perverse, and secondly, it is also, my lord, contrary to the court's own findings. I'll indicate why. My lord, will kindly take the affidavit in opposition filed by my learned friend today. They've enclosed a list of dates, which I admit the list of dates is accurate as to the proceedings before the trial court. In the affidavit in opposition, my lord, will kindly come to page 3. Page 3. My lord, will find para 7, there's a list of dates. This is accurate. I cannot dispute anything. This is as per the court records. All the orders are also enclosed in the copy of, in the supplementary affidavit I have filed. My lord, we'll see 10th April 2024, my client enters appearance in the suit after service of summons. Next page, 14 June 2024, there was a resolution of the bar. My lord, will find from the second column, from the left. There was a resolution of the bar, therefore no steps could be taken. That's there in there only, and it's also recorded in the order. Thereafter, my lord, what my client has done, they have failed to appear or rather take any steps. 21st August, we file an adjournment petition. Now, the adjournment petition, my lord, I'll show, I've enclosed a copy of that in my supplementary affidavit. The prayer in that time petition is time to file WS and or appropriate application. I'm just stating this is for the records. Thereafter, we do not appear admittedly on 27 September 2024. The suit is set ex parte. Thereafter, my lord, 6 March 2025 is when I file my Section 8 application. Now, what my learned friend does not indicate, or rather does indicate, my lord, will kindly take their entry. Defendant files petition praying for taking the matter off the ex parte board, files an application for under Section 5 and 8 of the Arbitration Act. The ordering portion is the rightmost column. The defendant is directed to serve copy of application under Section 5 and 8, and the plaintiff to file W. What they do not indicate is by this very same order, the suit is also taken off the ex parte board. I am allowed time to file written statement. Page 40 of my stay application, if my lord kindly takes now. page 40 of my stay application. But we'll kindly see page 40. I'm sorry. March 2025, my lord will see. My lord,
Prayer for taking of the suit is allowed.
And thereafter all the subsequent orders are part of my supplementary affidavit. Time is allowed by the learned court below for me to file my WS. I file my section 8 application on this very same day when time is also granted for me to file the WS. All the subsequent orders, even today as per instruction, time is being granted for me to file WS. Due to the pendency of this appeal, my lord, the learned court is not taking steps in that regard, is not putting the suit as an ex parte suit. So, my lord, my contention, I have a legal submission first and foremost. On facts, perhaps, my lord, I need not go further. On facts, my case, 2 dates, my client is at fault. We had prayed for time once, my lord, seen from the list of dates, and 1 day we failed to appear. And for that, explanation has been given in my stay application as well as the application for taking the suit of the ex parte board. My advocate, my lord, misplaced or rather misindicated in his diary. He could not appear. It was a fault completely. On our part, we bow down. It is 1 date. It is only 1 date. So, my lord, will kindly consider whether I have made sufficient cause. My lord, it fell from my lord Justice Rai on the last occasion that Booz Allen, the portion quoted by Honorable Justice Pratibha Singh in the judgment of the Delhi High Court, relied upon by the learned trial court. My lord, there Booz Allen says Section 8 application has to be filed at the earliest possible opportunity. Here, my lord, perhaps I have filed it at the earliest possible opportunity for whatever small delay that has been caused. Well, I've tried to explain it to the best of my ability. And on a point of law, my lord, Justice Singh's judgment in the Delhi High Court, the Bombay High Court judgment, which has also been relied upon by the learned trial court, they're all relating to commercial suits where a Section 8 application was filed beyond 120 days. This is admittedly a non-commercial suit. It's a title suit filed before the City Civil Court. 2 submissions on this. Number 1, Section 8, the provision of Section 8 has admittedly been amended by the 2015 Act. I looked into the Law Commission report. 246 Law Commission report was the report pursuant to which this amendment was brought about. Subject to correction by my learned friend, there is no indication in the Law Commission report at all in respect of the intention of the legislature behind this particular amendment of Section 8. Section 8 is amended to bring about the first few words, notwithstanding any judgment, decree, or order of court. That is discussed in detail in the Law Commission report. But as to this date, why date of filing written statement has been brought in, but that is not discussed. I've looked into the Law Commission report, that is not discussed. And the decisions of the Delhi High Court and Bombay High Court also do not say it is as per some observation of the Law Commission report. What the Delhi High Court and Bombay High Court says, in view of the Commercial Courts Act, if today a defendant is incapable of filing written statement, and the date for filing written statement which is crystallized and confirmed and mandated by statute has passed, then it amounts to submission to jurisdiction of the learned court below, because the court even otherwise could not grant him time to file a written statement. Here, the learned court below in a non-commercial suit has granted me time and fixed a further date for filing written statement. I have filed my application before that. And perhaps, my lord, that is what the law also has to be read insofar as non-commercial suits have to be. I have placed on the last occasion a judgment of the Honorable Madras High Court, where exactly this point was taken.
Mr. Mukherjee, by this order, you were granted time to file written statement.
Yes, the subsequent orders record. I'll indicate that. My lord will kindly
The suit was taken out from the ex parte board.
Yes.
That is one thing.
Yes, my lord. Time was also granted for filing written statement, supplementary affidavit. My lord will kindly take my supplementary affidavit.
Supplementary.
Yes. My lord, I file a supplementary affidavit pursuant to leave of my lord.
Mr. Amor Singh, no.
No, my lord. My lord,
Your on record is Mr. Amor Singh.
Yes, my lord. Yes. But it's been taken out of the ex parte board. Last year also तो तेरा सब हाँ Lord, 10 July, I'll just indicate. My Lord, has my subject?
Yes.
Yes. My Lord will kindly see. My Lord will see page 29 onwards. Page 29, my Lord, it's still not picked as an undefended suit. Defendant prays for an adjournment that is allowed 7/11/25 for hearing of the suit, but it is no longer on the ex parte board. There is no specific direction for me to file WS because of the pendency of this appeal. Immediately, my Lord will consider 6 March 2025 was the order where it was taken off the ex parte board and my section 8 was already on record.
What is the date of the impugned order?
Impugned order is 10 July 2025.
By this, your defense was struck off.
10 July 2025, defense was struck off. I've impugned this order. 10 July 2025, the defense was struck off, which is the subject matter of this appeal. Before this, my Lord, written statement was permitted to be filed. If I had come up with that written statement, but I had filed my Section 8 application beforehand.
Where is that order granting you time to file written
My Lord, if
statement?
it's, my Lord, 27th September was the order, my Lord, whereby my last chance to file written statement was closed and the suit was placed in the ex parte board. Thereafter, 6 March 2025, two things happened. The suit is taken off the ex parte board.
Yes.
And also my Section 8 application is
Correct,
on board. My
correct.
Lord.
Does that amount to granting you time to file written statement?
My Lord, my Lord, subject to correction, my Lord, if it's not an undefended suit, at that point of time, I could have filed an application praying for filing of the written statement as well. Instead of filing an application for acceptance, I'm sorry. Correct. Or else, my Lord, why would on 10 July my defense be struck off? If I didn't have the right to file a written statement at that point, I had chosen
For non-filing within the statutory period.
Yes, my Lord. Yes, my Lord. That statutory period is not a mandatory provision for insofar as non-commercial suits are concerned.
We are not on that. We are on whether or not, as a matter of fact,
Yes, my Lord.
time to file written statement was extended.
Lord, I had not prayed for that. 6th
That
March
is a different thing.
2025. Well, Lord, there are two options open to me. Once, well, Lord, the suit is taken off the ex parte board. There are two things open to my client. Either I can file my written statement along with an application for acceptance of that written statement, or I can file a Section 8 application. I have gone ahead and filed the Section 8 application.
Time was there.
It was there. At that point, if I sought, I could have filed my written statement. Normally, what the procedure is in the lower courts, my Lord is aware better than me. Normally, there are two applications filed for taking the matter of the ex parte board and for acceptance of
Non-commercial, so it is extendable.
It is extendable.
So it could have been extended had you prayed for.
Yes,
but you did not pray for it naturally because you wanted to file a Section 8,
which I
you
had
filed.
filed. I had filed on that date. On that date, I had filed.
Can we hear him?
My Lord, one judgment, my Lord, I want to rely upon. My Lord, will kindly take a judgment of the Honorable Karnataka High Court, my Lord, which is exactly on this point, my Lord, as per my. Copy though, Karnataka High Court. Neutral site is neutral. I have given the Karnataka High Court, I'm sorry. HDR Crime Corporation. My Lord, here Madras High Court was also on this point. I had placed Madras High Court on the last occasion, 2023 Madras. There also non-commercial suits were specifically considered. And my Lord, even though it was set expert and time to file WS had expired, even thereafter, the Madras High Court held, since this is a non-commercial suit, time is extendable and the time period for filing WS is directory and not mandatory. Therefore, it is irrelevant as to the delay. Here, my lord, is the facts in the Karnataka High Court decision are exactly the same in my submission, my lord. My lord, we kindly take the facts at para 3 and 4, and thereafter the ratio is at para 20. My lord, we'll see para 3. On 28th November 2022, pursuant to paper publication, the appellants and the respondent number 2 were served. On non-appearance of the appellants, they and the defendant number 1, i.e. the respondent number 2, were placed ex parte. Suffice it to state that 3rd July 2023, the appellants filed an application under Order 9, Rule 7 of the CPC, and also an application seeking to setting aside of the ex parte proceedings dated 28/11/2022 as no valid service, so and so, not important. On 4th August 2023, the application under Order 9, Rule 7 of the CPC filed On 4th August 2023, the application under Order 9, Rule 7 of the CPC filed by the appellants was allowed. They were permitted to file their written statement. The suit was listed on 13th September 2023 and 26th September 2023, when further time was granted to the appellants to file written statements subject to payment of costs, so and so. On the next date of hearing, i.e. 7th October 2023, I rely upon this, instead of filing written statement, the appellants filed an application under Section 8. This is, in this point of time, exactly what is the case here. It is taken off the ex parte board. Instead of filing written statement, I come forward with Section 8 application. My lord, now the ratio, and thereafter, my lord, that was dismissed. From that, the appeal was preferred. My lord, will kindly take page 16, paragraph 20. Having heard the learned counsel for the parties, insofar as the submission made by the learned counsel for the respondent number 1, that this is the submission that is being recorded, my lord. The learned sessions judge is justified in holding that the right to file written statement had commenced on the date of publication of the notice in the newspaper before so and so, and the written statement having not been filed within 120 days, the right of the appellants to file written statements stood forfeited, and as such, the filing of the Section 8 application under Section 8 of the 1996 Act much thereafter surely suggests that the appellants were not diligent. Then the comma after this is the reasoning, is not appealing, for the simple reason that such a conclusion is by overlooking the intervening fact, that is, passing of the order by the learned sessions judge on the application filed by the appellants under Order 9, Rule 7 of the CPC, by which the application having been allowed, whereby the learned sessions judge granted time to the appellants to file written statement and also gave further time on 13th September and also on 26th September 2023, by making it clear to file the same by 7th October 2023. And on 7th October, instead of filing the written statement, the appellants have filed an application under Section 8 of the 1996 Act. And also the fact that the respondent number 1 has not challenged the order of 4th August 2023. Here also 6th March 2025, not challenged. We are of the view, the finding that the appellants were not diligent in pursuing the remedy available under Section 8 of the 1996 Act is clearly erroneous and perverse. It is not a case where the application was filed after the expiry of the period granted by the learned sessions judge. The appellants were granted time to file a written statement by 7th October 2023. The appellants, instead of filing written statement, had filed an application under Section 8, which surely suggests the same was before the expiry of the time to file written statement. Here also, my right to file written statement had not been forfeited as on 6th March 2025 because of the alert.
Here, there was an express order granting the time.
Yes, absolutely. Absolutely. But again, it's the same. In fact, it is the same effect here. I file an application or taking the suit of the ex parte board. It is placed in the ex parte board when my right to file written statement is forfeited. Upon that finding, if that finding is recalled, if that finding in the 27th September 2024 order is recalled by a subsequent order, my right to apply for acceptance of written statement and filing written statement revives. I have a right as on that day to do either of two things: file a Section 8 and proceed to arbitration, or file an application for acceptance of written statement. with a condonation of delay, whatever it might be. I choose one of those paths. And in the overall conduct of the parties, my lord will kindly appreciate Booz Allen, which has been referred to by Honorable Justice Singh in the judgment of the Delhi High Court, which seems to be followed in the subsequent judgments. The main consideration was that the applicant under Section 8 has to come forward at the earliest to file a Section 8. Because Booz Allen in that paragraph 29, which is referred to, talks about submission to jurisdiction of a civil court. If by acquiescence a party submits to the jurisdiction of a civil court, he cannot thereafter turn around and say, I want to go to arbitration. My conduct in this case is categoric. The time petitions I have filed before the learned court below all say written statement and or appropriate application. Because at that point, there was no instruction specifically. I prayed for that time. I filed the appropriate application within the time stipulated. And my appropriate application, that is under Section 8. It's been considered. Finally, on 10 July 2025, Muller will again, at the cost of repetition, the learned judge does two things. Number one, Section 8 is dismissed. Number two, defense struck off. What was the reason, or rather, what was the necessity of passing that finding at all if my right had already elapsed? That is a part of the ordering portion, Muller. 10 July 2025, that's a part of the ordering portion. That since statutory time has elapsed, right to file written statement stands forfeited. Why make that observation on 10 July 2025 if I didn't have the right to before that come and apply for filing of written statement or acceptance of written statement?
No, ex parte, the expression ex parte may have different connotations.
Yes.
You can be set ex parte even after you file written statement.
Absolutely, my lord. Absolutely, my lord.
So that does not necessarily mean that it includes within itself the right to file the written statement.
Absolutely, my lord. It can be
That is one
absolutely.
way of looking at it, but there is another side also.
My lord, of course. But apart from that, my lord,
Correct.
Filing written statement, you can be set ex parte.
তুমি 10 দিন appear করলেন Your written statement is on record, but you are not appearing.
Then also you have depends on where what is ex parte. It needs consideration.
Today, my lord, it's been said ex parte before my filing of a written statement here. I had ordinarily, my lord knows from practice, my lord, normally it's either of the two applications. I seek, my lord, taking the matter of the ex parte board, simultaneously normal course, an application is filed for acceptance of written statement with the written statement, whatever it might be. I've chosen not to file that. I have said I am filing a Section 8 application. I've come within time is all I'm trying to say, number one. And number two, my lord, also on law, and also on law, well, the date for filing written statement, if we construe strictly insofar as non-commercial suits, well, that would go against also the judgments of the Honorable Supreme Court, which say it is directory. It can be extended at any point. Well, knows the judgment of the Honorable Supreme Court in a case from this Honorable Court itself in PIC developments. Well, 25 years of delay was condoned, and written statement was allowed to be filed in a suit because there was no progress made in the suit.
What is the citation?
It's an unreported judgment. I'll note it down, Malad. It's not there with me today. I'm carrying one judgment of the Honorable Supreme Court. Malad needs no. Malad, one judgment of the Honorable Supreme Court, 2022 SCC 708. Will kindly, Malad, one copy is not stitched. Malad will kindly forgive me. I mean, code is about it. Well, paragraph 13, it says in non-commercial suits, written statements, well, the time for filing continues to be directory. This settled proposition of law, paragraph 13, Malad can note. I'm not placing it in extenso. It's a settled proposition of law, right from Kailash versus Nanku and all. Big developments, Malad, I'll give Malad the citation also. I'll give it. Big developments versus big developments. Unreported judgment. I'll give it, Malad. It only says that non-commercial suits, the time for filing written statement is directory. So, my lord, if today.
Correct. Statutory period with the coroni, defense struck off, Section 8.
So, mathematically, developments and big developments. Big development. Yes.
And also, one more humble submission, my lord. Today, something should not be read into a statute which goes against the other statute or the provisions of the other statute. They have to be read harmoniously to a degree. If Section 8 says that it has to, a Section 8 application has to be filed within the time fixed for filing written statement, it has to be read harmoniously with the directory provisions of Section 8. Or rather, Order 8 Rule 1, I'm sorry, Order 8 Rule 1, which says that the time for filing written statement in a non-commercial suit is directory. It can be extended or modified even beyond the 30 days. So Order 8 Rule 1 says 30 days. Technically, if my lord goes by that strict interpretation, within 30 days, the statutory period for filing written statement expires. Strictly speaking, then after 30 days, no defendant can come forward and file a Section 8 application. Perhaps, my lord, that is not an interpretation my lords will adopt. Perhaps my lord will not adopt such a strict interpretation which restricts the right of a party. And my conduct I have placed for my list of dates, my lord. That's all. Deeply
My lord, in this matter, the only issue is that whether the applicant has waived his right to file Section 8 application in view of the amended provision of Section 8 of Arbitration Act, my lord. My lord, kindly allow me to place Section 8. Before coming to the fact, he has relied, the dates are admitted, my lord. I will come to later, but first of all, kindly allow me to place Section 8, my lord. My lord, may I? A judicial authority before which an arbitration is brought in a matter which is the subject of arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies not later than the date of submission of his first statement. My lord, this not later than the date of first statement, the date itself, the amended provision has imposed a restriction has fixed a time frame as regard to the filing of written statement. Here, my lord, the law is clear that submitting his first statements refers to the written statement, my lord, in a suit, because this is a proceedings before the civil court. So in a suit, my lord, on the substance there, then notwithstanding any judgment. So not later. It may come with the written statement or before the filing of the written statement, my lord. Section 8 is independent of the written statement, my lord. My humble submission is
this rating and non-commercial suit context, there is no rigid date for filing that is on
my lord, my humble submission is that Section 8 application is independent, separate from the written statement. It should be filed. Now, suppose a person, the party appellant had chose for an arbitration, he should have the very first instance have filed an Section 8 application before the statutory period of 120 days. I am coming to Order 8 Rule 1. Now, this is what I understand from Section 8 of the law. So there is a clear bar with regard to the filing of Section 8 after the statutory period or the time frame of filing the 120 days is over, my lord. Now, my lord, kindly come to my reply, my lord. The dates that have not been disputed, my lord. Reply to supplement. Mahato. Affidavit in opposition, my lord. My lord. Now, my lord, kindly take paragraph 7 at page 4. Page 4. The dates are there, my lord. 21st August 2024. Now, the trial court had given them the last chance to file, my lord, on a written statement as a last chance subject to acceptance, my lord. In every cases, my lord, if you can, my lord, goes to the order placed on record, is already given, my lord. They have been the subject to the acceptance of the written statement is there. Subject to the statutory period has been mentioned over there. My lord, the statutory period had expired on the 8th August 2024, my lord, from the first date of appearance, which I have already stated in paragraph page 6, my lord. Page 6, after the tabular form table is given, my lord, I've stated. I say that the statute period of 120 days expired on 8th August 2024, page 6, my lord, from the applicant's date of first appearance before the learned trial court on 10/4/2024. My lord. And thereafter, the applicant failed to file his even on 27/9/2024. That is the last chance given by the trial court, my lord, to file it. That is the last chance given. I say that as per the speed post track report filed by the learned trial court, someone in the suit was duly served on 28/12/23. So, my lord, it has already lapsed. There was no application, not even a single application. The court in its suo motu cannot extend the written statement, my lord, filing of written statement. An application should have accompanied with the Section 8 application, my lord, or for filing of written statement, my lord. I'm relying on the judgment of Supreme Court. Kailash. My lord, this has been followed up by the order passed by Salim Association as regarding to different settled principles has been laid down with regarding to different order sections and all. Kindly come to paragraph 42, my lord, at page 49.
(49).
499, sorry, my lord. Paragraph 42, my lord. Ordinarily, the time schedule prescribed by Order 8, Rule 1 has to be honored. The defendant should be vigilant. No sooner the writ of summons is served to him, he should take steps for drafting his defense and filing the written statement on the appointed date of hearing without waiting for arrival of the date of appointed in the summons for his appearance in the court. The extension of time sought for by the defendant from the court, whether within 30 days or 90 days, as the case may be, should not be granted just as a matter of routine and merely for asking more so when the period of 90 days has expired. The extension can only by way of exception and for reason assigned by the defendant and recorded in writing by the court to its satisfaction. It must be spelled out that the departure from the time schedule prescribed in by Order 8, Rule 1 of the court was being allowed to be made because the circumstances were exceptional, occasioned by reasons beyond the control of the defendant and such. Here, now like next paragraph, my lord. A payer seeking time beyond 90 days for filing of written statement ought to be made in writing, my lord. I'm stressing on the word ought to be in writing. There was nothing on record that a prayer has been made that praying for an extension or a condonation of delay for filing this written arbitration invoking this provision of Section 8, my lord. So, my lord, there was not even a single writing. That was one of the defense which was taken before the trial court by me. That he has missed the past, he has not taken any steps for seeking any time frame, making a time prayer, except that ex parte it should be vacated from the ex parte board. But that does not implies that he has got an opportunity to file a written statement, my lord. It should have been followed by a, though I'm repeating, my lord, it should have been followed with a application for filing written statement or condonation of delay for filing order, Section 8 of that application. Now, my lord, Section 8 does not make any difference between a commercial and a non-commercial suit. That has been observed by Justice Pratibha Singh, which has been relied by me in the lower court, my lord, and has been placed by my learned brother, that is at paragraph 22, my lord.
And handed up the SEC copy.
আমি SSC copy দিয়েছি।
Already.
No. If you already given us, then you don't give.
Then paragraph 22, my lord.
Don't burden the records. থাকলে আবার নিচ্ছ কেন?
My lord, paragraph 22 of
Is there?
Is there? My lord, can I take up paragraph 22, my lord? Thus, as per the above decisions, in view of the amended language in section 8, the limitation for filing the written statement under CPC for non-commercial suit and under the Commercial Code Acts for commercial suit would be applicable for filing an application under section 8. So it does not make any distinction, my lord, as regard to section 8 is concerned. The principle of Booz Allen's that it has to be made at the first instance is to be followed, my lord. In view of that, the court concluded the maximum period would be 90 days from ordinary suit for 100. In the non-commercial suit, my lord, in view of the Calcutta High Court amendment, the 120 days have been given. 30 days followed by 90 days. 120 days. 120 days have passed into 2024 in August, my lord. August. 8th August 2024. Now, as regard to the commercial and non-commercial suit, it is, I'm not on a quarrel, man. I'm not in quarrel with the proposition that 120 days is fixed for commercial. For non-commercial here in case, my humble submission is that the applicant should have made an application before the trial court seeking for extension of time. Now, one thing more, my lord, in their application for section 8, they have prayed that they should be exempted from filing written statement. That is that, my lord, if you can take. Huh? Page 44. 44, my lord. 49. At page 49, my lord. At page 49. Clear number C. Exempt the defendant from the filing of written statement. So I only disagree with the submission made by my learned brother that the time should have been given. Here he is already asking for an exemption from filing a written statement, my lord. Well, in that case, my lord, the applicant has already waived his right before the trial court, my lord. In support of this judgment, of this decision, in support of my argument before the trial court, I have relied on various judgments which has been supplied by my learned brother. That is, one is also of Bombay High Court. My lord, over there also, my lord, it has been held that section 8 is applicable for both commercial and non-commercial suit. And there is a Karnataka judgment also. Karnataka. Data. Karnataka. Of course. The Karnataka judgment also, my lord. Paragraph 17, 18, 19, and 20. has considered the view of the judgment, the decision passed by the Honorable Justice Pratibha Singh, my lord, and have upheld that. Also on that ground itself have rejected the Section 8 application on the ground of delay, my lord. Now, in the case of recently, in the case of Delhi, the division bench of Delhi High Court also considered this Justice Pratibha Singh's decision, my lord. That has also been affirmed and confirmed. That is a very recent case in 2025. There are no other authorities on this point negating the decision of on the point of Section 8, my lord. To my humble submission, my lord, even if it is a non-commercial suit, the statutory period is applicable, my lord, and that can only be extended by way of making a written application before the learned trial court, which was not done by my learned trial friend's client. Therefore, my lord, the right had accrued to me, and Section 8 as does not make any difference between the commercial and non-commercial, my lord. At the cost of repeating.
So if the limit, if what you're arguing, if the period prescribed by the statute for filing of written statement is to be considered as the limitation period for filing a Section 8 in a non-commercial suit, as we are dealing with, after 90 days, Section 8 becomes time barred.
Time barred, my lord.
After that, if time to file written statement is extended,
My lord.
again that time bar goes.
But there was no application, my lord.
We are theoretically, we are discussing
my lord, my lord.
If after that, so after 90 days, Section 8 application becomes time barred. After that, the court extends on an application made, extends the time to file written statement.
My lord.
So that time bar then goes.
My lord. ওটা তো বলে দিচ্ছি order 8 it has to be read with order 8 rule 1.
Within 90 days if the language is interpretation of the beyond the prescribed period is then 60 and 90 60 days 90 over there period prescribed and period prescribed is prescribed with the statute. The statute has given us firm date within such and such date. Impose a period of completion of the statutes, then that is another question which we need. Section 29 just go to last 6 months.
Huh? Petition agreement. Agreement नहीं है mediated agreement. It's only one point on limitation.
6 months. For extension. 6 months to expire. Then
আমার মনে হয় এমন তো করবে না
this was the
এসএসসি প্রতিভা সিং এর এসএসসি আছে
and you are also saying that it has to be in the case. If you find differences is absolutely listing. Earliest
21.
information is in the Senate. That is the
আমি এটা রিলাই করছি 22
Thank you. Thank you.
So, my lord, to invoke the provision of section, amended provision of section 8, the statutory mandate has to be complied by the person invoking or seeking for an arbitration. If that has not been complied with, then the appellant herein has waived his right to file the section 8 application. This is my humble submission. And as regard to the order relied by the Chennai High Court by my learned brothers, is that it relates to the pre-amendment period. It is not after an amendment period. He has appointed.
When did the amendment come?
In 2015.
2015.
2015.
And Chennai was before that.
Chennai was before that. It was dealing. No, it was dealing. It was dealing with the case. The fact of the case was dealing with before the amendment, my lord.
Anyway.
My lord, may I please order 8 rule 1?
Perhaps not, my lord. Here also the suit was 2021 in the Madras High Court. That was also a suit of 2021. OS number 252 of 2021 was filed before the additional subordinate court. From that the appeal arose. Post 2015. One submission. If my learned friend has concluded. বলতে পারেন ভুল 2021 দেখো 20 তো ভুল যাবে সেটা
Who is filed, but the, my lord, this is referring to the agreement prior to the 15/10/2019 and November 2017. These are.
No.
It's a case, my lord. Paragraph 10. Kindly take up paragraph 10, my lord, of the judgment relied by Madras High Court, my lord, to show that it is a pre-amended provision. Paragraph 10.
Madras High Court.
The present case of someone was served upon the defendant on 17/11/2011. এটাই তো দিয়েছেন আপনি।
এটা হচ্ছে because আগে 2021 suit number 2021 হচ্ছে।
এটা তো আপনি দিয়েছেন।
ভুল করে এক দুইয়ের মধ্যে এক লিখেছেন।
আমি কি করে বলতে পারবো? আমাকে যা লেখা আছে সেটাই, ওইটাও ভুল হতে পারে না।
23 দেখুন, ঠিক সেকশন 8 কোড করা আছে। 23 টা দেখুন, দেখুন আপনার ডেট অফ ফাইলিং। Date of filing, correct?
No, they have considered that amended provision at that point of time. Consider that provision.
Judgment whatever it was. The amended provision is considered. Two lines in reply if my lord permits.
Yes.
Number one.
One thing, sorry, there is another judgment which I have come yesterday night, passed by Honorable Justice Moushumi Bhattacharya from the Tenalaga High Court, upholding the current provisions. If leave be granted, if I can
upholding the current provisions?
Upholding the decisions of the other Delhi High Court and other high courts.
Her lordship couldn't have upheld.
No. Sorry, my lord. So if a leave be granted, my lord, I will file.
Yes, file it. Can you file it in course of the day?
In the course of the day, my lord.
It's all on the same proposition. It all stems from Justice Singh. Justice Singh is the my lord. Her ladyship really the architect in respect of this field of law. I had also never come across this field. My learned senior friend order from the trial court, my lord, really enlightened me as well. I was not aware of this at all. Of course, there are not only two submissions in reply. Madras High Court deals with post-amendment, my lord, para 23 quotes the amended section 8, just on that, number one. Number two, every single one of the judgments being relied upon my learned senior friend All of them relate to commercial disputes. Perhaps a line is there in respect of non-commercial suits. At best, it will be obiter. It cannot be the ratio of any of those decisions. Perhaps a line is there. Those observations, Malad will kindly consider, they cannot be in consonance with the law of the land in respect of non-commercial suits. It's directly contrary to every single judgment of the Honorable Supreme Court, number one. And only, Malad, one other aspect, I'm very sorry, Malad. Malad, Booz Allen is what Justice Singh relies upon. I want to read 2 lines from Booz Allen and then conclude, Malad. Para 28 of Justice Singh's judgment quotes Booz Allen, paragraph 29. May I just place this paragraph once for my satisfaction? Though Section 8 does not prescribe any time limit for filing an application under that section, and only states that the application under Section 8 of the Act should be filed before the submission of the first statement on the substance of the dispute, the scheme of the Act and the provisions of the section clearly indicate that the application thereunder should be made at the earliest. Obviously, Madam, kindly note these words. Obviously, a party who willingly participates in the proceedings in the suit and subjects himself to the jurisdiction of the court cannot subsequently turn around and say that the parties should be referred to arbitration in view of the existence of an arbitration agreement. Whether a party has waived his right to seek arbitration and subjected himself to the jurisdiction of the court depends upon the conduct of such party of the suit. My client has missed one date, prayed for time on another date before the crucial day of 6th March 2025. On 6th March 2025, my client has sought to have the suit removed from the ex parte board, allowed. My client at that point of time, if the ex parte board removal was granted at 11:59 p.m., at 12 o'clock midnight, my client has come forward instead of filing an application for acceptance of WS to file a Section 8. Even prior to filing written statement, my client has come. My client could have sought subsequently to file a written statement. Before that, I have my application under Section 8 on board. If I had filed the application one day after, I would have been hit. But I filed them on the same very date.
You're right, absolutely. Maybe merit address করো that amounts to absolutely.
My lord, one thing more, may I submit one thing more, my lord. That order 8, whatever the submission is made by my learned friend is, but subject to the condition, my lord, order 8, rule 1. Order 8, rule 1 does not provide unrestricted freedom to the defendant to file the written statement whenever they choose. It has to be an application.
You said so.
My lord, I'm at the cost of repeating, my lord.
We will copyright this. We will keep this matter once again on the 23rd. Today is the 11th, 23rd. If we have, if we want any clarification from either of you, but you can give us that Telangana today.
Telangana, my lord, I will.
And I'll also give my lord peak developments on
Yes.
written statement. I'll give that during the course of the day.
Yes.
Today I'll.
Yes. Lekho. Heard learned counsel for the parties at length. Paragraph. List this matter once again on September 23. 23 টা হচ্ছে এই কমার্শিয়াল তো কিন্তু এটা বিফোর নন কমার্শিয়াল 23 or 2025 to be heard before commercial matters. নাকি টাইম করে দেবো কি টাইম করে দেবো Mark 10:30 p.m. Or not before commercial, no, mark 10:30 a.m. PM, PM, no, AM.
Lordship,
পাঠিয়ে দাও আমাকে পাঠিয়ে দিও না
Lordship, before rising, may I permit?
We'll come back. Yeah. Yes.
A leave, I'm going to mention for leave for grant of but leave to drawn up the decree, Your Lordship. That I should mention the morning, Your Lordship.
Decree dated?
Lordship, on dated 28th April 2025. My Lord, leave be granted.
Actually, original site though. Original site.
Site, my Lord.
We leave to. Very well. We'll come back at 2 p.m.
Grateful, my Lord.
My lord, I'm for the petitioner.
And I appear for the respondent back. I have received the soft copy yesterday.
Yesterday?
This is the
You want some time?
affidavit of service.
Yes, first, my lord, I have received instructions to apply for review against this order, my lord, from the side of the bank too. My lord,
Oh.
that is being filed. My lord, if it so commences to your lordships that both the reviews, though not filed, though not on record, but
Can you tell us when by what time it will be filed?
Monday.
It will be filed.
Yes, it will be filed.
Very well. We'll post it immediately after the vacation. Before vacation, it may not be possible. Isho. This is an application for review of the judgment and order dated July 7, 2025, whereby MAT number 106 of 2020 was disposed of by us.
2024.
Stop. This review application has been filed by the
Writ petitioner.
By the respondent oblique writ petitioner.
Yes.
Respondent oblique writ petitioner. Paragraph. Learned advocate appearing for the bank. The appellant bank says that he also has instructions to file an application for review of the same judgment and order. Stop. He says that such application is likely to be filed by next Monday, by next week, by next week. Paragraph. Let this application be listed immediately after the ensuing puja vacation. Whenever this bench is available, at a bench kore diyo, bujecho? First week ei kore diyo. Stop. Wherever this bench is available, stop. If in the meantime the bank files any application, comma, the same shall also be listed along with this application on the adjourned date. Chalo.
They have filed this review with around 20 grounds.
20 grounds.
My lord, perhaps your lordship has said MAT 106 of 2020. It should be 2024, I guess.
20 bolechi? 2020, not 24. Thank you.
Obliged, my lord. Greatly obliged.
My lord, may be permitted to file a separate sheet of paper indicating the relevant paragraph, my lord. Item number 12, my lord, of Moushumi Bhattacharya.
ওইটা নিয়ে না ওই যে এটা চলছিল
I've indicated the different paragraphs. Great.
ওটা ফাইলে দিয়ে দিও
Oh. ইয়েস রাখুন লিস্ট রাখুন Item 13.
Number 13.
ইয়ারগুলো কি তো
But 13, I'm for the appellant, my lord. On our last occasion on 4th of September, when the matter was taken up, my lord, the paper book volume, it was big. That day we thought was a compilation of, we taken out that, some documents and we have made, my lord, 2 copies on the relevant only, the agreement, the award. না না সাপ্লিমেন্টারি না ওইটাকে ছোট করে যেটা প্রয়োজন আছে সেগুলোই খালি This is under the 1940 Act. Sometime in 1st of March 1970, no one is there to apply.
We know, we remember that.
Well, 1st of March 1971, well, agreement was entered between one Himjit Construction with Kolkata Metropolitan KMWSA, which is now KMDA. The clauses of the main agreement was the value of the agreement was 6 lakhs, estimated value 6,55,000.
What was it for, the agreement?
For a tolerance pipe, laying pipe of pipe and tolerance. It was 6,55,000. The earnest money was 16,000 only. This agreement was done and there was a time period by which it has to be completed. It was 2 years. In the meantime, what happened? This Himjit it was dissolved. Thereafter, the predecessor interest of the present respondent who are not appearing, he stepped into issue, one Mr. Himanshu Bharadraj. Here what
The
happened?
agreement was not with Himjit. Himjit.
Himjit, the proprietor was
No, partners of Himjit were Himangshu and Jitendra.
all of them were there. No one. Thereafter, Himangshu Bharadraj came, and this agreement was the partnership firm. This gentleman was carrying on it. The work which was supposed to be done within 2 years, there was a delay. Well, it kindly comes to page 104. From 1 to 103 is the agreement. Comes to 104, that is the first supplementary tender of Himjit Construction. With that 6,55,000 of the first agreement, Malad, there was another amount of rupees 7,387, 108 page.
Well, 108.
108, the last page, my lord, kindly comes to 108 with pen, not with the not the printed one, with pen. 108, my lord, kindly comes. This first supplementary tender, they say, that is amounting to rupees 7,387.
The printed 108. Hate lekha 108. There are 2 page marks, page numbers.
Well, the one with black ink, not the other which is printed. Printed probably is 202 there, but it's actually 101. এটা একসঙ্গে করে দিতে পারবো।
হাতের লেখাটা তো এসেছি কি বলছে? Yes, first supplementary tender.
Yes, it starts at page 104.
Yes.
Kindly comes to page 108.
Yes.
Again, serial number 7, the total quantity and the total amount is rupees 7,387.
Yes.
This is the total amount. So initially it was 6,55,000, and thereafter this 7,387. This is the total amount.
Yes.
So, well, admitted fact that the claimant had received rupees 9,13,539. That will come later on. It's an admitted fact. Now they say that I am supposed to get 14,98,000. That they went for arbitration. And it comes straight away come to the award. Award starts at 109 and kindly comes to 115. It starts at 109.
Yes.
Well, that's the
115.
award with reasons, it's from 112. May I read the order or may I just go to the ordering portion? Kindly comes. There were as many as 10 issues which were raised. The 115, after that issue number 10, the above are the only reliefs the parties are entitled to, and they are not entitled to any other relief. We hereby direct the respondents, Kolkata Metropolitan Water and Sanitation Authority, to pay the claimants Himjit Construction, represented by Himangshu Bharadraj, the following amounts. Claimants claim 678,520. Another claim that is for extra work which was not assigned to them. That is 8,01,000. Claimants claim 100 and 10,000. Total 14,90,000. We further direct that the said amount be paid within 45 days of the date whereof, failing which the awarded amount will carry interest at the rate of 15% till the date of payment or the date of decree upon judgment upon the award which is earlier. We further direct that the respondents pay rupees 1,500 to arbitrator Mr. Tathagato Roy towards his fees for 25th of July 17. Pursuant to the order of Justice Banerjee, we had deposited 15 lakhs rupees. Punjab National, we have deposited 15 lakhs rupees. It's there.
15 lakhs.
50 lakhs.
Justice Shonji Banerjee.
Justice Oshim Banerjee.
Justice Oshim Banerjee. Where is that order? In what application that was passed in section 34?
List of dates today? Duto day. 30th of May 2009. Arekta day?
In your 34 application.
Follow. I was just going.
In which proceeding this?
In this proceeding, it came out in High Court appeal. We had appealed against the order of passed by the Civil Judge Senior Division 5th Court. But once they had put the award into execution, my lord, well, then the execution is also pending. In the suit, this award was word to word, verbatim same. We came up against appeal against that order.
Did you challenge the award?
Yes.
By way of what?
Well, by way of an application under section 34 of the Act.
That is exactly what I was asking you all the time.
Probably I could not follow, my lord. Then we deposited that 15 lakhs.
The 34 was heard by whom?
By Justice Banerjee's bench, my lord.
Right.
And
We
there
now
was-
understand.
on 30th
And
of
your
May-
34 was dismissed.
Yes. Then, my lord, this 30th of May 2009 is the order. But just kindly see the order. I have given this list of date once before also. একবার দেখে নিন আমাকে দিও। আচ্ছা আচ্ছা।
Why are you complicating things, Mr. Das? This is an award. You challenge this under section 34. Where is the 34 order?
My lord, kindly comes to
Initial order directing you to deposit 50 lakh or 15 lakh.
my lord, that
And the
is
final.
May 30, 2009.
This is the list of dates. We want to see the order.
My lord. Well, we have missed out that order copy. দেখে নিন হ্যাঁ দেখে নিন আছে নাহলে আমি নিয়ে নেবো আরেকটা।
You could order sheet, Bobby. This is a 37 appeal. How will you get it in the order sheet? That order was passed in this appeal.
Yes, in this appeal, we were there. I appeared in
By
that
whom?
By Justice Oshim Banerjee and 30th of May 2000.
Just now you said Justice Oshim Banerjee heard the 34.
Maybe I'm Justice, it was the order passed in this appeal by Justice Oshim Banerjee's bench.
Who heard 34?
This is against one of the suit was disposed of. The suit was order was passed by this the suit on May 7, 2002. 7th of May, this order was passed. The award was made on December 22. The suit was award holder filed the suit on 7th of May. We filed an application under section 30 before the civil court. We lost. Thereafter, we came in the appeal. Once this suit was there, we came in appeal. In the appeal, this order was passed for depositing rupees 15 lakhs.
Award holder filed a suit.
Yes. My lord, kindly comes to page 116. I have marked it. Page 116, my lord, will kindly comes.
3033.
Therefore, this was made of court.
Must be.
No, that was the
In the 9th Court of Civil That Senior Division, page 116 it starts. This is an application by the award holder, 14.2 and 17 of the old Act, 1940 Act.
14.2 and 17 chilo to make it. 14.2.
We file our objection there.
What was 14.2?
Well, 14.2 kindly comes to page there. The old Act 1940, my lord. Award to be signed and filed. 14.2. Well, initially that was the 1940 Act matter. As related with section 17, we filed our objection there also.
Pronounce judgment. Judgment and
Mala, the prayer is at 120.
Where is the 3033 order? There was no section 34, Mr. Das. You haven't read your papers at all.
Read.
What read? This is a 1940 Act proceeding.
Initially, I told him, this is an old Act 1940 Act.
No, you did not say that.
When I started the matter, I said that.
Where is the 3033 order?
Half chole gache paper.
The order in the setting aside application, where is that?
Well, it will kindly come. Well, affidavit in petition under section 30 of the arbitration, page 128, my lord, will kindly comes. My opposition is at 125, at 188, 128. An application under Section 30 of Arbitration Act 1940, that the claimant has filed an application under Section 14(2) read with Section 17 of the Arbitration Act to be praying inter alia for pronouncement of judgment in accordance with the award published on 22nd of December 2000 under Section 15.
Where is the final order on this application?
Well, the final order on this application is at page 158. It starts at 158. Well, the ordering portion is at,
Title suit.
yes. Well, that is why it was made. Initially it was 71, then it comes at page 70.
This is 14 to 17.
Yes, 14 to 17. Thereafter, madam, under 30 we filed our objection. And this is the final judgment and decree.
Section 30 is a separate setting aside application.
Well, I don't find here anything. Section 30 application I read out just now before my lordship.
The order disposing of that application.
I'll check with the thicker one.
এটাতেই বোধহয় কনসিডার করেছে, এটাই বোধহয় only order.
Well, it starts at page 158, it ends at page 190.
এখানেই application section 30 বলে শুরু করেছে। মনে হচ্ছে তাই, আমি জানি না,
Here it says that the suit B and the same is decreed on contest with cost against the defendant respondent. The claimant plaintiff Himjit Construction being represented by Mr. Himanshu Bharadwaj, the sole proprietor, gets a decree in terms of the award passed by the learned arbitrator, such and such. Then let the award be made a part of the decree. This was at page 186. Thereafter at 187 the judgment. Then we preferred an appeal. Madam. The appeal proceedings before this Honorable High Court, there was an order for depositing rupees 15 lakhs that we have deposited. That was in 2009.
30 is rejected. And this is allowed, 14 and 17 is allowed. This is the impugned order then.
Yes. ওটা বের করিস না, ওটা একই। ওহো, ওটা এতে আছে। অত কনফিউজ হয়ে যাবো।
কোথায় শুরু হচ্ছে?
Well, it starts at page 158 till 190. পেজটা দেখা দিই মোটাটা। করে দিলে আরো ভালো হতো।
What is wrong with the award?
Well, kindly comes from grounds number 7 onwards. Well, what happens here? The work which was assigned to them, well, before the arbitrator, we stated that whatever work has been assigned to them has been written, signed by both the parties. Here, the extra work which this gentleman was claiming, well, it was never assigned to them. Well, it kindly comes my application before the court where it will show.
Give us the 1940 Act once. Give us.
Well, I have one copy, but I'm giving.
Give us one copy.
Mobile.
So which ground under section 30 you are relying on? It was the other.
Well, a memo of appeal, my lord, will kindly comes from ground number 7. That
Not
is one.
memo of
And
appeal.
from here, my lord, will kindly comes to. One I am not relying. One is that the arbitrator or umpire has misconducted himself. This is certainly not. That an award has been made after the issue of an order by the court. That an award has been improperly procured.
None of the grounds.
None of the grounds. This is fair.
No, then where does your section 30 stand?
This just kindly comes to my objection there written. 2-3 pages I'll read.
Objection?
Page 143 it starts. Right? Internal page 32 na কত ছিল দেখ my petition at 128 128 my lord will kindly comes. Well, this is at 128. This is my humble petition of Calcutta Metropolitan. This is my just comes to this 2-3 pages. 128 it starts.
Yes.
Well, that the claimant has filed an application under section 14(2) read with section 17 of the Arbitration Act, paying inter alia for pronouncement of a judgment, that the facts of the case in a nutshell as follows. Tender number
Page 143 you're reading.
Now, pen 128. 128.
Very well.
Ink.
Yes.
Well, that the claimant has filed an application under section 14(2) read with section 17 of the Arbitration Act, paying inter alia for pronouncement of judgment in accordance with the award published on 22nd of December under section 14(2) of the Arbitration Act and 17. The facts, well, kindly comes here. Tender number 19 of 1970 valued at rupees 6,55,000 was floated. An agreement dated 1st of March 1971 between KMDA, the applicant, and HIMD, the partnership was for construction of RCC box at SC Mollig Road. That against contract estimate of rupees 655, amount received was rupees 930, which at the initially I said it was the value of 655, but he had raised bill. We have paid them also 9,13,000 as per bill prepared by executive engineer of the applicant, which included the value of the extra additional work. The claimant accepted payment the said bill of rupees such and such by signing on 12th of March 1986 without recording any objection. That though the work was completed on 6th of March 1975 and the contractor firm is stated to have been dissolved on 31st of March 1976, the claimant kept it suppressed, and the claimant, describing him as proprietor of Messrs. Himjit Construction, raised a fictitious bill of rupees 678 on 9th of April 1986 and also claimed interest at the rate of 18% from 7th of March 1975 arbitrarily and motivatedly. The alleged claim was lodged by the claimant on different heads amounting to rupees 20 lakhs long after completion of the work on the plea of verbal order for extra work without any cogent and supporting document. Well, there was no verbal order as such. That subsequently, as per order dated 17th of August 1989, passed by the learned Third Court Civil Judge Senior Division at Alipur in Miss Case 36 of 1986, two arbitrators, Mr. Das and Mr. Tatagato Roy, Professor of Construction Technology, Jadavpur, were appointed. The learned arbitrators were entering into the reference on 5th of February 1993 and passed their award on 22nd of December 2000. The award passed by the learned arbiter suffers from disqualification of legal misconduct, and also there are mistakes apparent on the face of the record and is liable to be set aside. Well, the kindly see the grounds. For that, the learned arbiter wrongly interpreted the terms of construct and did not take note of the order dated in the miss case. For the learned arbitrators failed to consider the facts that the tender followed by written contract was for an estimated work of rupees 6,55,000 and the petitioner respondent paid and the claimant received running bill of a sum of rupees 9,19,000 out of the total value of the work as per done of 9,13,000. Further, the learned arbitrators neglected to consider the fact that the claimant received the bill on signing on 12th of March 86 without any objection as specifically stated by RW2 Sri Paja, and as such he cannot raise any dispute about the said bill on a subsequent date. Thereafter, the learned arbitrator did not dispose of the preliminary objection dated 1st of September 1993 of the petitioner respondent that was promised by an order dated such and such. Then, for that, the learned arbitrator neglected to take note of the evidence of the claimant to the effect that the firm submitted income tax return and he could not recollect if the return indicated, well, then it misconducted themselves. He has written, not disposing the preliminary objection in 4 above, which essentially related to scope and jurisdiction, and by approaching. Then, not recording as per law of evidence copies of the letters after the date of the venue of a sitting passed an order. These were the grounds which were taken in the objection. Only thing was there was no verbal workout, nothing. This was the only ground, and this was not considered by the learned joint arbitrators. The award, the last 2-3 paragraphs, if I am permitted to read again, I will kind of say this is totally, it was silent. He received the money. 6,55,000 was the estimated value, the value. Thereafter, he raised a bill of 9,13,000. It was paid to them. Now he has filed for the award. It was nearly 14,90,000. Further, the learned arbitrators failed to consider the evidence of the claimant that the recorded measurements and those were in his file, but he did not produce the same before the arbitrators. Well, the spot visit, my lord, what the content of work which was done, whether at all it was subsequently assigned to him, failed to consider the fact that cement and steel were to be supplied by the applicant respondent, and without his written order, those could not be purchased from the market. Well, these are the grounds which were raised before the learned court below in the objection, stating that the extra work was never given. তো 15-তে আছে না? আমাদের আরেকটা 40 অ্যাক্ট আনা উচিত ছিল। As many as 10 issues were মানে will kind to পেজ 112টা খুল হ্যাঁ পেজ মিলছে তো And from page 112, the award with reasons.
What was claim A in the state
Well, that amount 6,55,000.
on account of extra work?
No, it was the original amount, the work. Thereafter, my lord, he comes up with say that my officers have given him extra work, but no documents have been shown, nothing. And the remaining part, 8 lakhs is interest. And in
Where is the statement of claim?
my lord, it kindly comes to
Sure.
109 থেকে শুরু
Final bill amount. That's fine. Fine. Interest খানিকটা দিয়েছে।
পুরোনাতে আছে 203 এটা একটু দেবেন না 203 অরিজিনাল পেপার হ্যাঁ 203 বের করে দেবেন মানে 203 of 3 of the earlier one, my lord, it has a page 213 statement of claim. It starts at 203. 213, my lord, kindly comes. It starts at 2003, at 203, and it's at 213. Thank you. খুব ভালো লাগে এই জন্য এর আরেকটা কপি কোথায় বের করে বল একটা কপি আর কিছু আছে এটা নেবে কিছু বার করবি কি করে যত বড় ব্যাটার যত বড় টেক্সট গুলো আরেকটু বড় করে পড়বে। In G, PH. G is 100, H is the 10,000 দিয়েছে। ও বল জিজ্ঞেস করে লাভ নেই কিছু। Can you enlighten us, Mr. Das? The statement of claim contains. Page 203 of the thicker one.
Please listen to us. The statement of claim contains claims which are not reflected in this award at all. The claim in the statement of claim is principal claim, is 20 lakh. But the arbitrators from the very beginning say that the principal claim is 6,78,000.
6,55,000 plus that amount.
Irrelevant. Was there an amendment to the statement of claim?
Never.
You appeared in the arbitration.
No. Well, we came sometime in 2017 or 18. তাই তো? হ্যাঁ? 17-18 আর একটু আগে হয়তো। 18। এইটা কোথায় ছিল? লস অফ বিজনেস মাসলা এরকম কিছু প্রখ্যাত।
আর এটা কোথায় যেন ইমপিউন্ড অর্ডারটা কোথায় একটু দেখলাম 158 না? This appeal, this is a very old appeal of 2008. So it would appear from the previous orders recorded by us that the respondents have withdrawn from the appeal. Stop. Nonetheless, we tried to cause service of notice on the respondents. Stop. The notices came back unserved since the respondents have moved from the, since most of the respondents have moved from the,
One have refused.
since two of the respondents have moved from the recorded address Stop. One of the respondents has refused service, which amounts to good service. Paragraph. This appeal is directed against an order dated March 22, 2005, passed by the Court of the Third Civil Judge, bracket Senior Division, bracket close, Alipur, South 24 Parganas, in title suit number 41 of 2002, instituted by one of the respondents herein, namely, Himanshu Bharadwaj,
He expired.
against the appellant's predecessor in interest, Calcutta Metropolitan Water and Sanitation Authority. Stop.
Now KMDA.
Paragraph. The brief and relevant facts of the case are that a contract was entered into by and between the predecessor in interest of the appellant, paragraph, for the sake of convenience, hereinafter referred to as KMDA. And the predecessors in interest of the respondents for laying of RCC pipes in branch and lateral drains in adjoining areas under Tollygunj Stream Drainage Project scheme. Stop. The agreement was dated March 1, 1977.
71.
Huh?
71.
71. ভুল লিখেছে জাজমেন্টে March 1, 71. Stop. There was a supplementary. Where is that?
Well, at page 104 it starts. First
Supplementary tender, which was submitted by Himjit Construction, bracketed, predecessor in interest of the respondents, which was for an amount of rupees 7387.25. Stop. The original contract was for the sum of rupees
6,55,000.
6.55 lakh approximately. Paragraph. The contract between the parties contained an arbitration clause for resolution of disputes between the parties. Paragraph. Disputes arose between the parties in relation to the aforesaid contract. Stop. Himjit Construction, bracketed claimant, by a letter dated April 9, 1986, addressed to the chairman of KMDA's predecessor in interest KMDA, requested that such dispute be referred to arbitration in terms of the arbitration clause contained in the contract. Stop. The dispute appears to be concerning a sum of rupees 6,78,520.57 along with interest, which the claimant contended was payable to it by KMDA. Stop. Paragraph. Joint arbitrators were appointed. Stop. The arbitrators published their award on December 22, 2000. Stop. Paragraph. No, 2000. Stop. The award directed the KMDA to pay rupees 6,78,520.57 and rupees 8,01,676.70 to the claimant on account of work done, extra work done, and interest pendentility, respectively. Stop. A sum of rupees 10,100 was also awarded on account of costs. Stop. Paragraph. Since the provisions of the Arbitration Act, 1940, 20 left. So, governed the arbitration proceeding, the claimant made an application, initiated proceedings under sections 14 and 17 of the 1940 Act for obtaining a judgment and decree in terms of the award that was made in their favor, in its favor. Stop. The KMDA filed an objection to such proceeding under section 30 of the 1940 Act. Stop. In such objection, KMDA prayed for setting aside of the said award on various grounds. Paragraph. By the judgment and order impugned herein, the learned trial court rejected KMDA's objection and allowed and passed a decree in terms of the said award in favor of the claimant. Stop. Hence, this appeal at the instance of KMDA. Paragraph. Mr. Das, learned counsel representing KMDA tells us that rupees 15 lakh was deposited by KMDA in court in terms of an order passed by, you have a copy of the order?
I don't have, but
Order dated
May 30, 2009.
In terms of an order May 30, 2009, passed by a coordinate bench,
Justice Ashim Kumar Banerjee, Justice Prosenjit Mondol.
coordinate bench at the time of admission of this appeal. Paragraph. On the merits of the appeal, comma,
ওই 15 লাখ টাকা জমা দেওয়ার অর্ডার হয়েছিল। Well, they say that it's March 30, 2019, not May.
আমাকে গুলিয়ে দেওয়ার জন্য সবাই খুব চেষ্টা করছে। March 30, 2009, ঠিকই। On the merits of the appeal, comma, on the merits of the appeal, comma, Mr. Das submitted that the learned trial judge failed to appreciate that the award was based on no evidence. Stop. No extra work was done by the claimant. Stop. The entire dues of the claimant were paid. Stop. The claimant received such payment without any reservation or objection. Stop. There was no material on record on the basis of which the arbitrators could have allowed the claim on account of work done, oblique extra work done. Stop. Therefore, the question of awarding interest did not arise. This was the crux of the argument of Mr. Das. Paragraph. We have gone through the award as also the order of the learned trial court sought to be assailed before us. Paragraph. We deem it appropriate to extract relevant portions of the award hereunder. করে page 113 থেকে বুঝেছো of this এই পেপার বইটা ইস্যু নাম্বার 4 দেখবে এখানে আছে আমি দাগ দিয়ে দিলাম পেন্সিলে আর ইস্যু নাম্বার 7 কোয়েশ্চেন আনসার যা আছে দুটোই দিয়ে দেবে হ্যাঁ এই দুটো দিলেই হবে তো পরের পাতে ইস্যু 8টাও দিয়ে দেবো তাহলে হয়ে যাবে খবর হ্যাঁ আর ইস্যু 8টাও 6, 7, 8 হ্যাঁ সরি 4, 7, 8 তাহলে এক কাজ কর না ফোর থেকে এন্ড অব্দি দিয়ে শোনো তুমি ইস্যু নাম্বার 4 থেকে এন্ড অব্দি দিয়ে দাও দু পাতা আছে ঠিক আছে পেজ 113 paragraph. We therefore see that the award is based on evidence and is a well-reasoned one. Stop. It cannot be said that the award was passed on the basis of no evidence at all, or that there was no material to support the claim made by the claimant. Stop. Paragraph. Coming to the order of the learned trial court, comma, again, it may be helpful to set out the relevant portion of the order as under page 182, bracket করে দিলাম, থেকে 186 bracketed portion. Paragraph. A bare perusal of the aforesaid portion of the impugned order would show that the learned trial judge applied the correct principles of law. Stop. The learned judge, the learned judge rightly observed that he was not sitting in appeal over the award. Stop. He noted that the grounds for challenging an arbitral award are limited. Stop. After scanning the award, the learned trial court came to the conclusion, and in our view, rightly so, that there is no error apparent on the face of the award. Stop. The learned judge correctly observed that he was not to judge the quantity or quality of evidence that was there before the arbitrators. Stop. The learned judge found nothing perverse in the award so as to in the award. Stop. In the award. Paragraph. We are having read both the award and the impugned order, we are in complete agreement with the learned trial court. Stop. We do not find any such perversity either in the order of the trial court or in the arbitral award as would persuade us to interfere. Stop. One must bear in mind that an arbitral award is not to be lightly interfered with. Stop. Paragraph. The order under appeal does not warrant any interference. Stop. Accordingly, the appeal is dismissed. Stop. There will be no order as to costs. You really thought you will succeed in this one?
Sorry, not that, but
there is prima facie.
The interest portion, I'm really aggrieved by that interest portion.
Very well. No, nothing can be done. Interest claim was 14.
Maybe.
Award was much less, almost half now. So 330.
I was never very hopeful, but at least I thought the interest portion would have gone. That 8 lakhs amount interest, no double payment. Once they take 9 lakhs, again this amount. But I'll take it. আমি দিয়েছি, আমাদেরটা একটা দিয়েছি।
হ্যাঁ, correct. সেগুলো তো এই সেট অফ পোর্শনে চলে গেছে। 2008 appeal, thank God. Oof.
I'm not feeling well also for the last 2-3 days.
Yes, take care of yourself, and the dust from this 2008 paper must have.
But one paper book I have handed over.
Hey, keep paper boi চাইছেন।
না, একটা মোটা দিয়েছিলাম না, পেজ 203টা বের করে। আচ্ছা ঠিক আছে, আচ্ছা ঠিক আছে, তাহলে আমাদের কাছে দুটো থাকবে, একটা ডিপার্টমেন্ট নেবে।
ঠিক আছে।
বলছি 14 ডাকবে তো? এক্সকিউজ মি ম্যাম, 14 ডাকবে না? সিক্স ম্যাটার 14 কল করবে না? মানে কখন কল করবে তাহলে? আপনার কি সিক্স ম্যাটার?
Our notes are ready. I am ready to proceed. There is no issue. That would it be Lordship's pleasure to take it up after vacation? Because it takes some time.
So I have no difficulty because we've got the money subject to a bank guarantee.
We have got it.
Yes, your Lordship's order was there of 2024.
Oh, really?
Given a counter guarantee and take it.
We've taken.
Then you're really in no rush.
We are in no rush because we've seen the color of money. So
Yes, Mr. Sir, since it's going to take some time,
difficulty, not if my learned friend wants.
yes, come back after the vacation. The weather will be better in Calcutta.
It's always a pleasure to be in Calcutta, my lord. The history and culture of this place is always an attraction.
Last orderটা দাও না, সবসময় আগে ফাইলটা দিবে। Are you filing your notes of argument today?
Yes.
We can file. My lord.
Yes, yes.
You can file and you can exchange also. That will.
Yes. This is for the.
So just let me. One thing I just.
Yeah.
Yes. As far as we are concerned, my lord, the appellant is concerned.
Mr. Dutt. You are Mr. Dutt.
Yes, ma'am.
Yes. Give us a date in the first week of November or second week of November, as the case may be.
First week of November. I had actually not asked my clerk for a date in the end of October.
We can give you in end of October, no problem.
30th October, if it's.
30th is a holiday.
I see.
For what reason, I can't remember.
28th.
28th is possible. We reopen on the 24th. 28th is possible.
It may be better November without any.
Very well. Whatever date, then it suits
subject to Lordships.
6th November.
6th.
As far as the appellant.
In case there is any difficulty, can I come back and mention? I'll have to check with
Most
my clerk.
Certainly.
I'm grateful. 6th November.
Our notes is very short, but we also have a list of dates along with that.
We have also a list of dates. We didn't file it, we didn't hand it across because the order didn't say so. But we also have a.
No. Because my challenge are 2 counts. One on the merits of the award, one on the, it's an ex parte award. So that's why the list of dates assumes significance.
Service. It's not really an ex parte award because according to us, and that's what is recorded even in the award, that the ICC arbitrator gave them opportunity for 10 months every time, by register ID, by email, nobody responded. It's only when the when the proceedings were closed and draft award was sent to ICC under the ICC rules, draft award has to be sent to ICC just on the procedural, as a procedural formality. After that, they moved an application, and he has he has dealt with it in detail, and the 34 court has also looked at it and come to a conclusion that they had all opportunity. They chose not to participate despite service and despite email and register ID service repeatedly.
34 court is the High Court or
The
Commercial court.
commercial court.
Asansol?
Yes. And on merits also, my lord, the arbitrator dealt on merits also because they are really, the claim is, my lord, based on an interpretation of the contract. They say that you SENVAT credit, a minimum guaranteed amount was there in the contract. And they withheld from our bills saying that you've not met the minimum guarantee.
Mr. Dasgupta, is this the same point?
No, no. There is some difference in the wording of the contract. Here it says we have a right to
You
recover.
understand which point, which case?
Sitting with my Lord Justice Chattopadhyay.
Yes.
SMS case, my lord, is it?
SMS.
There was another case.
There are several.
The learned arbitrator said the excise duty went down at least 4 times during the course
Yes,
of the
yes,
contract.
yes,
So
yes.
where is I can't pass something more than what the tax I have paid. So that on merits, my lord, he has interpreted the contract. It's really, my lord,
Yes.
that's what
Unless it's perverse, the construction.
perverse. It's at the 34 court says it's a reasonable interpretation.
There are actually, my Lord, several matters similar but not necessarily the same contract.
No, may not be the same contract.
Contract in the sense those clauses, those relevant provisions.
We'll see.
Yes,
We'll see.
definitely.
List of dates and written notes of argument filed on behalf of both the parties be kept with the records. Paragraph. We have heard learned counsel for the parties briefly today. Stop. The long puja vacation is knocking on the doors. Stop. Hearing of this matter is likely to take some time, as is submitted by learned counsel for the parties. Paragraph. As agreed by and between learned counsel for the parties, comma, list this matter once again on November 6,
3:30, my lord.
comma, 2025, comma, marked 3:30 p.m.
Great.
Now may I have a copy? Thank you.
Other list of the thing I have given.
Notes you have given? Notes also. I think what we have done is, I think we have also handed. Can I have another copy? Or you can send by confirm from that clerk. Yes, yeah, sure. Stop. Okay. Thank you.
Grateful.
Thank you, Mr. Are all of you from Delhi?
Yes. All of us.
All of you. Good.
It's always a pleasure, my lord, coming to Calcutta. That's what I was saying. And since there is no pressure, the client has the color of money in his hands. So you've
Right.
seen the color of money. So
Yeah.
we are in your lordship's hands. Grateful.
Controversial item number 14.
Lordship. Advocate Nilanjan Bhattacharya and Advocate Deepanita Ganguly is appearing on behalf of the appellant. But in today, Advocate Nilanjan Bhattacharya and Deepanita Ganguly both were present at the morning, but both have left the court due to their urgent situation. And we have already served the copy. We have been already tracking the ID, but today morning when...
Who are you for?
So we're representing National Stock Exchange.
Oh, yes.
Okay, so we cannot confirm that whether the service is completed or not.
When will
because
you be able to
due to the server problem of the India Post, we cannot see that what is the current status of this.
So tell us what we should do.
Kindly give us, Lordship, keep this matter in the any day of the upcoming week, Lordship.
Next week, next Thursday?
Okay, Lordship.
Likhe now.
Great.
On the request made by learned advocate. Hey, এটা কে? Shondip, Mr. Dipan, you are Deepanita Ganguly? No.
No, Lordship, I'm her junior.
Achha. Mr. Deepanita Ganguly. On the prayer made, on the request made by learned advocate for the appellant, let this matter stand adjourned and be listed again on Shamne Brishputivar.
Grateful.
Grateful, Lordship. Ma'am, the matter will be taken up in the next Thursday, right?
I have a, this matter I have a malod, tough road to go through.
The vacation.
No. Let us finish it, malod, if I can. But there is an interesting judgment which we found out, which said, malod, that section 87 is ultra virus. That, malod, makes a very dangerous situation. That takes care of 26 also of the Arbitration Act. Malod, we were just having a conference on that. The judgment is judgment দিয়ে শুরু করি তাহলে judgment এনেছিস তো হিন্দুস্তানটা এনেছিস তো আমি এনেছি বুঝলি হবে না আমি প্রিন্ট করব There's a 2020 judgment of Justice Malod in the Hindustan construction matter, where Malod this issue cropped up and Malod has been dealt with, section 87, and says that it becomes, he's declared Malod as ultra virus.
This court?
No, Supreme Court. So now, Malod, the effect of that is directly on section 26. So that is why, Malod, when I was reading through the judgment, it's a very lengthy judgment. Malod, the after effect of that is something very, Malod, distortful, because, Malod, Lordship remembers the BCCI judgment, which says, Malod, makes a category that, Malod, what court will do and what proceedings prior to 26 would do. Very clear. This judgment, Malod, makes it a little hodgepodge, because this considers also, Malod, BCCI, and ultimately, Malod, holds, which is little, Malod, if I may just, BCCI, Malod, he has dealt with it, Malod.
You mean 26 of the Amendment Act?
Hey, please, thank you. Yes, the one that they relied upon. And the other matter also, Malod, Lordship will remember I was relying upon. No, এসে গেছে ওর কপি আছে হ্যাঁ This is the situation, Malod. Every day Supreme Court comes up with a new view.
Paragraph 57 onwards,
Malod kindly takes paragraph 10 first, because there, Lordship will find that BCCI is considered. It's been relied upon by just Mr. Call. Kindly will see paragraph 10, Malod, first. Mr. Such and such appearing for Hindustan Construction reiterated some of the paragraph 10. It SCC to AI diyechi. Or does the paragraph start with Mr. Neeraj Krishan Call?
Paragraph 15.
15. I'm sorry, Malad, I'm reading from the AIR paragraphs made different. Also appearing for Hindustan Construction reiterated some of the submissions of Mr. Such and such and argued, based on a reading of section 87 as introduced by the 2019 Amendment Act and section 26 of the 2015 Amendment Act, the acts which we were showing to my lord, a direct attack on the judgment of BCCI without removing its basis. He has also added that since there is no set-off of mechanism provided by the Insolvency Code, the provisions of Insolvency Code will have to be held to be manifestly arbitrary so far as my client is concerned to this extent. Then, my lord, kindly sees, Mr. Such and such reiterated the submission that section 87, being directly contrary to this court's judgment in BCCI, as I showed BCCI on the last occasion to my lord, needs to be set aside. He also argued that it retrospectively removes a vested right in the petitioner as it reflected in paragraph 62 and 63 of the BCCI judgment. Now, my lord, apropos these submissions, now kindly sees the finding, my lord, of the court. My lord, kindly comes to paragraph 48 onwards. My lord, my paragraph 48, this.
You
my
will
lord,
take the rest of the day, Mr. Banerjee.
I think, my lord, after that, lordship would like to rise and have a coffee, my lord.
After?
After, my lord, I finish somewhat, lordship would like to have a coffee, my lord.
No, so we can release it
Yes,
to the
yes,
friends.
I think, my lord. This
Matter, can it be next Thursday?
Yes. The next matter, you are for the appellant.
For the
Who's for the respondent? Ask your junior to inform them.
16th.
Yes.
Now, my lord, this paragraph starts with the Sri Krishna committee report.
Your paragraph number is?
48. Won't
Be 53 here.
kindly sees, my lord, Sri Krishna committee report. The sentence starts with.
No, তাও হচ্ছে না, মিলছে না।
Dated, Sri Krishna committee report is dated 37
Well,
2000.
paragraph 60.
60. Paragraph 60.
The Sri Krishna committee report is dated 37 2017, which is long before this court's judgment in BCCI. Whatever uncertainty there may have been because of the interpretation by different high courts has disappeared as a result of the BCCI judgment, the law on section 26 of the 2015 Amendment Act being laid down with great clarity. Because lordship remembers that judgment, there, my lord, the Supreme Court held that, my lord, arbitrations beginning before the amendment would not follow, but court proceedings, my lord, filed, my lord, during the amendment or before the amendment can, because the arbitration, my lord, is not affected, because the court can take cognizance of the amendment, but the arbitral proceedings won't. So they made a clarity there. Now, my lord, this kindly sees apropos that the Supreme Court's observation, my lord, why Mr. Chidambaram argues that, my lord, this should be set aside because this is in direct conflict with the BCCI judgment, this, my lord, amendment or the, my lord, act, my lord, becoming repealing it. Kindly sees, my lord. To thereafter delete this salutary provision and introduce section 87 in its place would be wholly without justification and contrary to the object sought to be achieved by the 2015 Amendment Act. My lord, I will show after this the two amendments of 2015, section 26 and the section 87 amendment, which, my lord, takes away the right, which comes in 2019.
And BCCI is?
BCCI is 2018, because BCCI is in between the two, the first amendment and the second amendment. Now, my lord, kindly, my lord, if I may read through. To thereafter delete this salutary provision and introduce section 87 in its place would be wholly without justification and contrary to the object to be achieved by the 2015 Amendment Act, which was enacted pursuant to a detailed law commission report, that's the above mentioned report, my lord, which found various infirmities in the working of the original 1996 Act. Also, it is not understood as to how uncertainty and prejudice would be caused, as they may have to be heard again, resulting in an inconsistent position. The amended law would be applied to pending court proceedings. That's exactly what I was saying, my lord. Pending court proceedings, which would then have to be disposed of in accordance therewith, resulting in the benefits of the 2015 Amendment Act now being applied. To refer to the Sri Krishna committee without at all referring to it, to this court's judgment, even after the judgment has pointed out the pitfalls of following such provision, would rather render section 87 and, my lord, will kindly mark the deletion of section 26 of the 2015 Amendment Act manifestly arbitrary, having been enacted unreasonably without adequate determining principle, and contrary to the public interest sought to be subserved by the Arbitration Act 1996 and the 2015 Amendment Act. This is for the reason that a key finding of the BCCI judgment is that the introduction of the section 87 would result in a delay of disposal of arbitration proceedings and an increase in the interference of the courts in arbitration matters, which defeats the very object of the Arbitration Act 1996, which was strengthened by the 2015 Amendment Act. Now, my lord, apropos this, kindly, my lord, takes paragraph 51, because thereafter, my lord, the judgments have been quoted. That's, my lord, also it is important to notice.
Paragraph 63.
63. আচ্ছা কি পেয়েছিস?
হ্যাঁ, তোমার আমার প্যারাগ্রাফ এক, আমার সেকশন।
আচ্ছা ঠিক আছে। Also, it is important to notice that the Sri Krishna Committee report did not refer to the provisions of the Insolvency Code. After the advent of the Insolvency Code on 1/12/2016, the consequence of applying Section 87 is that due to the automatic stay doctrine laid down by the judgments of this court, which have only been reversed today by the present judgment, an award holder may become insolvent by defaulting to its payment to its suppliers when such payments would be forthcoming from arbitral awards in cases where there is no stay, or even in cases where conditional stays are granted. But this, my lord, portion I was just reading to show that, my lord, the amendment also, my lord, had an effect with the Insolvency Code, which came into, because, my lord, earlier it was, my lord, automatic stay.
Paragraph 54.
So therefore, my lord, what would have happened, my lord, a person filing a Section 34 would get an automatic stay, and what proceedings there in the Insolvency and Bankruptcy Code would also get affected. But today, my lord, that's not possible. And today, in view of the further amendment in the IBC, that's even not possible, because, my lord, the moratorium sets in, and, my lord, there cannot be any proceedings by which, my lord, I can come and say that, my lord, there is a stay, so you cannot proceed against me. So these amendments came up.
Paragraph 54.
Yes. Now, my lord, kindly comes to paragraph 54. My lord, where, my lord, the ultra virus part starts, my lord. Kindly comes to, this is, my lord, the result is that the BCCI judgment. The result is that the BCCI judgment will therefore.
Paragraph 66.
56.
66.
66, my lord. The result is that the BCCI judgment. এই যে মিলছে তোর?
Continue to apply. এটাই তো, unlike.
In this copy, it's always Kochi cricket judgment.
The same, my lord, the only
Yeah,
the
we know, but
Kochi versus
it's unusual.
BCCI.
This is not right.
Yes. That is SCC.
It's not right. Which is more authentic, this one or that one, what you are reading?
AIR, my lord, not only, my lord, says the BCCI judgment, but also in the bracket quotes the citation also, my lord. 2018 SC 1549.
Anyway.
হ্যাঁ
তোমার আমার প্যারাগ্রাফ সেম, স্কেলেরও সেম।
The result is that the BCCI judgment will therefore continue to apply so as to make applicable the salutary amendments made by the 2015 Amendment Act to all court proceedings initiated after 23/10/2015. In this view of the matter, it is unnecessary to examine the constitutional change of the 2019 amendment based on Articles 19(1)(g), 200 and 300 capital A of the Constitution of India. Now, my lord, kindly sees, my lord, thereafter it is been quoted. Now, kindly, my lord, will take paragraph. না এরপরে আছে
73 onwards একটু আছে, but then that is again lastly IBC.
না যেটা ওইখানে বললো না যে ইয়েস আরেকটা পোর্শন আছে না যেখানটাতে বলছে যে অ্যামেন্ডমেন্টটা। give me one moment, my lord. ওই যেখানে বললো যে ইয়েটা ওটা আলট্রা ভাইরাস কোনটা
53 তার আগে প্যারাগ্রাফটা।
And my lord, kindly takes the last paragraph which I want to show, my lord, is just the paragraph before that Kochi, my lord, lordship read, paragraph 53. 53, my lord, just the paragraph before that. Amending Act এনেছিস?
হ্যাঁ আছে।
Now, my lord, kindly sees, in the present case, the challenge is not to the fixing of 23/10/2015. That's, my lord, the amendment date. as the cutoff date, as the aforesaid date is the date on which 2015 Amendment Act came into force. For this reason, the aforesaid judgment have no application. Instead, what has to be found to be manifestly arbitrary is the non-bifurcation, this is very important, of court proceedings and arbitrary proceedings with reference to the aforesaid date, resulting in improvements in the working of Arbitration Act 1996 being put on a back burner. This argument of the Attorney General of India also therefore must be rejected. So, my lord, this, apropos this,
এটা তো আগে দেখিয়ে দিয়েছো কোনটা এই যে আলট্রা ভাইরাস এই পয়েন্টটা তো for all the reasons deletion of section 26.
and my lord kindly will quote, my lord, the Honorable Supreme Court has just prior to that, in the paragraph that I was reading, my lord, which was paragraph 51, also it is important to notice that Sri Krishna Commission report, Lordship, has just to the end of that paragraph declares it ultra virus. My lord, kindly will see the sentence starts for all these reasons. Lordship has found, my lord, the deletion of section 26 of the 2015 Amendment Act, together with the insertion of section 87 in the Arbitration Act of the 2000 is struck down as being manifestly arbitrary under Article 14 of the Constitution.
The deletion of 26 has been struck down, which means 26 is reinstated.
Yes.
Where's the problem?
No, the problem lies now, my lord, with our matter. With our matter now, the facts of our case. The problem is not that, my lord, I take an advantage of that. Now, kindly sees now, my lord, section 26. So we come back to 26 there, of the amending act. I think at a copy I think, my lord, a copy was given.
Copy was given. Whether we'll find it or not, I don't know. দেখো এর ভেতরে এখানে কোথায় আছে
2 page, I think, my lord.
2-3 পাতার জেরক্স কপি করে দিয়েছিলেন ওইটা ওই জিনিসটা
ওটা 19টা, ওটাতে 87টা এলো।
19টা আমাদের কাছে এক্সট্রা কপি আছে।
19টা তো লাগবে না, 19টা তো করলো তো।
এক্সট্রা কপি আছে আমাদের।
Yes.
Now, my lord, kindly take section 26 now.
Next.
Notwithstanding contained in this act, should have been nothing, sorry, my lord, nothing contained in this act shall apply to the arbitration proceedings commenced in accordance with the provisions of section 21 of the Principal Act. Before the commencement of this act, unless the parties otherwise agree by this act, shall apply in relation to arbitral proceedings commenced on or after the date of commencement of this act. Therefore, my lord, here kindly sees, my lord, unless it is agreed, it would not apply. And that is where BCCI clarifies, my lord, not like a court case. Now, my lord, we have an unique case. Why I say this? Because, my lord, kindly sees the date. Then I'll show Ilora, my lord. Kindly sees the dates here. My lord, kindly takes এটা পেপার বুকটা কোনটা বল?
এটা হচ্ছে পিটিশনটাই এতে আছে আর কি। তুমি ওই ইমপিউন অর্ডারটাই দেখো।
হ্যাঁ বল না সেটা।
ইমপিউন অর্ডার ইন্টারনাল পেজ 6।
My lord, the impugned order, if your lordship takes the paper book, it's internal page 6, my lord. Paper book পেজটা বলতে পারবে? হ্যাঁ, এটাই তো।
এটা হাইকোর্ট। এটা পিটিশনে আছে।
ও এই যে
ভলিউম 1 পেজ 40।
ভলিউম 1 এর পেজ 40। পেজ 40 বলছো?
ভলিউম 1 পেজ 40 অ্যানেক্সড ইট।
কিন্তু আরবিট্রেশন অ্যাওয়ার্ড।
এটা ভলিউম 1। ওটা আপনি যেটা দেখছেন ওটা
এটা তো অ্যাওয়ার্ড।
এটা অ্যাওয়ার্ড। ইমপিউগড অর্ডারটা।
ইমপিউগড অর্ডারটা ভলিউম 1 এ আছে। তাই ভলিউম 1 মানে এই পিটিশনে অ্যাপিল
পেজটা
এখানে দেয়নি, ওরা ভলিউম 1 সেটা নেই এটা।
দেয়নি, ওরা আলাদা করে দিয়েছে।
ওটা পিটিশনে আছে। একটা দেখুন এরকম
একটা পিটিশন ফাইল করেছে, তাতে রয়েছে।
মেন অ্যাপিলে যেটা আছে, মেন অ্যাপিলে
পেজ 4
ভলিউম 1 এর
ভলিউম 1 এইটা আপনি যেগুলো দেখবেন ওগুলো সাপ্লিমেন্ট।
এটা তো পিটিশন, পেজ 4 তো পিটিশন।
মানে থেকে শুরু
যেটা সাপ্লাই করেছে সেটা তো পিটিশন। এটা
আপনি সাপ্লিমেন্টারি থেকে
ও, এটা সাপ্লিমেন্টারি। ওইটা ওরা একটা সাপ্লিমেন্টারি ফাইল করেছে, পেজ 4। বলছি এটা তো নয়, মিলছে না বাবা।
এটাই
হ্যাঁ দেখ,
ইন্টারনাল পেজ 6 টাই যা।
আমার কাইন্ডলি টেক্স ইন্টারনাল পেজ 6 or page 8 মালন। ইন্টারনাল পেজ 6 মালন পেয়েছেন?
অফ দি অর্ডার।
Internal page 6 of what?
Of the order মালন। তোমরা এটাই ফাইল করেছো তো? Paper book was filed by them.
We have the award before us.
No, not the award. Impugned order মালন, against which they have come up.
Impugned order তো মেমোতে দেখো না, মেমোতে নেই।
1 and 2 ওইটা
এটা ইনিশিয়াল অ্যাপিলটা দেখ। এই তুমি দাঁড়াও,
এটা পেয়ে যাবে, এটা পেয়ে যাবে পেজ।
হ্যাঁ
পেজ 3।
হ্যাঁ 3 থেকে শুরু হচ্ছে।
6
এবার পেজ
আপনি ইন্টারনাল বলছেন এটা
এই কোনটা বলছি? এইটা
এখানে আছে, এটাই লড়াই আমরা।
Now my lord, kindly sees page 6.
Internal page 6.
Internal page 6, running page 8. My lord, the second paragraph starts with firstly. Lordship has seen firstly the word. Internal page 6, running page 8. Firstly, I find that Sri Dr. R.K. such and such of OP Corporation and thereafter such and such, and then executive director such and such were appointed as sole arbitrators on, kindly mark this, my lord, 25/11/2013 and 10/11/2014 respectively. That is prior to introduction of the 7th schedule of the said act on 23rd/10/2015. But the arbitral proceeding, just like Ilora, but the arbitral proceeding did not actually commence before either of them, as the issues were framed for determination only on 30/9/2016, and that is, my lord, admittedly after the amendment. Now, these dates are very important. Why I say, my lord, this takes us, my lord, to the realm of that amendment, and my lord, I am entitled to the relief as has been granted. These dates are very important because, my lord, there was arbitration শুরুই হয় ওইখানে অ্যামেন্ডমেন্টের পর।
এক্স্যাক্টলি, এবার পড়ে যাও।
দাঁড়াও, ডেটটা দেখি তো ঠিক আছে। তোমাদের যতটুকু কি বাবা, কি নোংরা।
ছাড়ুন, 26 amending act. এবার arbitration did not actually start সেই জায়গাটা।
26 আমার অ্যাপ্লাই করে দিল
না, এই আর্বিট্রেটর পরে অ্যাপয়েন্ট হয়েছে আফটার দি অ্যামেন্ডমেন্ট।
সেটাই তো
বলছি, এই জন্য পড়তে বলছি, was appointed on 7/6/16.
Now may I read the next line, my lord, because the next line will make it more interesting. Now, my lord, kindly sees, this is the first part. Secondly, my lord, well after the said amendment came into force, before learned arbitrator Mr. such and such, who was appointed on 7/6/2016. So the tribunal which passed the award was appointed only on 7/6/2016. Admitted situation. Which is also after the said amendment came into force. Moreover, learned arbitrator did not make any mandatory disclosures in terms of 6th schedule read with section 12(1)(b) of the said act. That's the separate part. But, my lord, the arbitral tribunal which, my lord, participated in the reference, accepted it and conducted the proceedings and passed an award was appointed on 7/6/2016.
Banerjee, just thinking aloud.
Yes, my lord.
once an arbitration proceeding commences
Yes.
in terms of section 21
Yes, my lord.
of the Act, and let's say suddenly, God forbid, the arbitrator dies,
Yes.
the arbitration proceeding comes to an end, and when another arbitrator is appointed, it's a fresh commencement.
Why I say this, my lord? This
Unlikely.
is no. Why I am saying this, my lord? Kindly, my lord. This is something kindly considers. My lord, lordship will now see the law as it now is. When there is a section 14, my lord, filed before my lords nowadays, as the law has been settled by the Supreme Court, it says that section 14 de jure de facto lordship removes. Lordship removes the arbitrator. Lordship cannot appoint. Now the appointments, they say, has to.
Sorry.
That's all right.
Yes.
The appointment, they say, my lord, now has to follow the original procedure. But if there was a section 21, then I have to go to section 21 again. And my lord, I have to get an appointment. That's the law, my lord. Unfortunately.
There has to be a fresh 21.
Yes. Yes, my lord. That is exactly what I'm saying. This is the law as settled now. The original procedure has to be followed. And if
in the meantime, the limitation?
No, my lord, the section 14 will come into being. They'll say that, my lord, we had proceeded diligently. Why, my lord? If it was an appointment by 14 read with 15, 14 read with 15, then my lord can appoint. Then it won't be fresh. Then it will be by 15 lordship can appoint, because the earlier one was 14 read with 15. Because I have, my lord, before Justice Moushumi Bhattacharya, my lord, I have done this because she was also startled. I said, this is the law, my lord, I can't help. I have to go back to section 21 again, wait for 30 days, get an appointment, and then, my lord, I have to file a section 11 and get it appointed. There's no way. That is why I'm saying, my lord, this is the startling facts of law.
এবারে ওই জায়গাটা বার করে দাও যেখানে আমি পয়েন্টটা নিয়েছিলাম, হতে পারে আমার নর্মালি টিচারটা অন্য, কিন্তু আমি পয়েন্টটা নিয়েছিলাম, তুমি ডিসক্লোজার করোনি এবং তুমি অ্যাপ্লিকেশন আছে ওটা বার করে রাখবে। দেখাবো দেখাবো ওই জাজমেন্ট গুলো নিয়ে আসতে হতো, তাহলে দেখিয়ে দিতাম এই পয়েন্টটা উঠলো বলে ওই অরিজিনাল প্রসিজার ফলো করতে হবে। সেটা তো তুমি যাই হোক, ঠিক আছে, নেক্সট দিন আনবো। ঠিক আছে, চাপ নেই, সব
Yes.
So therefore, my lord, this which fell from my lord, we had to burn our fingers, my lord. We can't help. We have to go back to the same procedure. And if required, file a fresh section 11, get it appointed. 14, 15 is different, my lord. But 14, if your lordship, my lord, agrees with me, de jure de facto, and removes, then, my lord, I have to go for the original, my lord, procedure. So if that be so, my lord, then it's get constituted, new constitution, because then 21 will come into being. 21 language is very clear, my lord, on the date that he receives, constitutes the arbitral tribunal.
New constitution is not important. It will be a new commencement.
Yes, because kindly sees 21 language. If I issue a section 21 notice, if today, my lord, let us say lordship was hearing a 14, my lord. Lordship is with me, lordships are with me. এটা আমার বই, এটা আমার।
ও তাহলে তুই এটা দিয়ে আমারটা
ট্যাগ চুরি করছো।
না, ওটা আমারই ট্যাগ।
তুমি আরেকটা লাগাও।
আমার এটা অ্যামেন্ডমেন্ট একটা নেই।
নেই।
আচ্ছা, রেগুলেশন
বেশি আপডেটেড বই কিনেছে 15 এটা নেই।
না না অ্যামেন্ডমেন্ট একটা আছে।
তোমার ওখানে নেই।
এই তো
কোথায় আছে
ঠিক তো। আচ্ছা ইন্টারন্যাশনাল এইসব নিউ দিল্লি ফিউ দিল্লি
নেই নেই এটা 19-এ ওটা দেয়নি
কি রে
সব থাকতে
না না এত রুলস ফুলস ঢুকিয়েছে তো দেয় না
পচা রুলস ফুল ঢুকিয়ে দিয়ে তোর বইটাকে বাল্কি করে দিয়ে
সত্যি কথা মানে আমার মাথায় আছে তো সেটা মোর ইম্পর্টেন্ট
আসল জিনিসটাই নেই
ওইগুলো এক একটা এক এক রকম একই কোম্পানি না
একই কোম্পানি একই
দেখ কমার্শিয়াল এরিয়া.
So they, because my lord kindly sees the language, my lord, of 21, commencement of arbitral proceeding. So the moment I issue a new notice under section 21, I am commencing a fresh arbitral proceeding.
No, this is on the assumption that the law requires you to
Yes.
issue a section
Yes.
fresh.
If
That law
lordship,
we have to see.
if lordship wants today, I don't have, because since it fell from my lord, I
Is
can
it a
give the
Supreme
judge.
Court?
Supreme Court judgment, and my lord, High Court's also following it because they have to, my lord. Can't be helped. I have to go back to the original procedure.
No, no, we'll have to see. Not making any sense, Mr. Banerjee.
Yes, it does not, my lord. In fact, just think of, my lord, a litigant who might be, my lord, doing an arbitration for 2 years.
Yes.
Then, my lord, it can happen
Yes.
that, my lord, for reasons
Evidence
it can
is
be de
complete.
jure, de facto, my lord.
Evidence is complete, argument is going on.
এটা তো আলাদা আমাদের ক্ষেত্রে সেটা
De jure, de facto, and then, my lord, I come before my lord, lordship sets apart. Lordship says, no, correct. He has acted, my lord, either under de jure or de facto. And, my lord, I have to go back to the original procedure. It happens. It has happened to me in many a times, my lord. Award being passed there, my lord, before the award being passed, my lord, somebody takes the point, we have to, my lord, do it. Especially, my lord, in cases of unilateral appointment. Unilateral appointment, my lord. They, my lord, appear later on. Then they come and say that, look at it.
Same if the unfortunate death of the arbitrator.
Yes, my lord. Death is an my lord, incident that is, my lord, takes place. But, my lord, the procedure has to be that. But I can't file a section 11 and say, my lord, there is a death, so appoint. I can't, my lord. And even if I file a section 11, it would be the original procedure. I'm going back to the original procedure. So the language is such, my lord, in 21, if I issue a notice, it's commencement. আমাদের ফ্যাক্টস অনেক বেটার, সেটার কথা বলছি না।
না মাঝপথে মারা যাওয়ার আমাদের আর্বিট্রেশন শুরুর আগেই চেঞ্জ হয়ে গেছে
Section 15, that is of read it. Can this provision in addition to this? In addition to the circumstances in section 13 or 14, section 13 provides the circumstances in which it can be terminated. The 14 also provides the same. In addition to this, these. And in such cases where the mandate terminates, a substitute arbitrator shall be appointed according to the rules. So the result of section 14 must be section 15. It can't be 20.
ওই জাজমেন্ট দিয়ে দেবো নিয়ে আসবি জেরক্স করে নিয়ে আসবি হ্যাঁ দিয়ে দেবো তোকে সুপ্রিম কোর্ট আছে বম্বে হাইকোর্ট আছে দিল্লি আছে আমাদের হাইকোর্ট আছে
মারা গেল
বুঝতে পারছি কিন্তু আইনটা তো
Yes.
So therefore, as I say, my lord, our facts are much better because, my lord, before commencement even, nothing has happened. Lordship is saying midway it happens, then one has to go back. But here, my lord, the constitution takes place even before, my lord, anything happening. Because, my lord, it takes place on 7/6/2016. Amendment is of October 2015. So therefore, my lord, I say that, my lord, apropos the facts of my case, of course, my lord, I'll show those judgments so that lordship is convinced with my submissions that I have to go back to the original procedure. It's the commencement which takes place. My lord, I have made, my lord, a prayer before the arbitral tribunal which passed an award that you are de jure not entitled to continue with the procedure because you are hit by Perkins, you are hit by the subsequent judgments, my lord, that a person who is not entitled to, my lord, espouse his own cause cannot become an arbitrator. He does not rule upon the same and pass an award. And that's been upheld by the trial court, against which they have come before, my lord. So, my lord, on merits, I have a very good case on the award. But I do not wish, my lord, that my lordships need not go into the merits, because this is hid by the now the my lord settled law that a person who is interested in the cause cannot become an arbitrator.
The passes an award which has been upheld by the trial court.
No, the award has been set aside by
That's
the
right.
trial court. That's what I'm saying, my lord.
Award was a nil award against you or something like that.
No, nil award. Nil award against me, but by a person who was not entitled to pass an award under the law. I had taken the point, and now, my lord, against that they have come up before, my lord. So, my lord, I say that in view of the dates and in view of the application of section 26, I'm entitled to the amendment. So if I'm entitled to the amendment, my lord, then there
Although the arbitration commenced prior to the
then
2015
my lord,
amendment.
BCCI will apply. That's very clear, my lord. Then, my lord, 26 will not come into being for me as far as my dates are concerned. I won't get the help of my lord BCCI there. Because that makes a distinction with court cases and arbitration proceedings initiated prior to the amendment. And this judgment, my lord, declares 87 to be ultra virus. Therefore, 26 comes into being then. If 26 comes into being, then, my lord, I get the advantage of the date, that's 7/6/2016. Because, my lord, lordship remembers Ilora. Ilora also held, my lord, since arbitration has not begun for 11 years due to, my lord, an order or injunction passed by the court. Therefore, it's a commencement takes place post amendment, although the arbitration proceedings started, my lord, 11 years prior to the amendment. If your lordship remembers Ilora, my lord, I can hand over a copy of the Ilora judgment. I think, my lord, that's been handed over. It says, my lord, that Ilora is there before, my lords. I've referred to even. Paragraph, I may read, my lord, paragraph 6 onwards, if your lordship sees in this, the if your lordship takes, my lord, from paragraph 6 onwards, Ilora judgment,
6, 7, 14
the arbitral tribunal was constituted, called as the Stationery Purchase Committee, comprising the officers of the respondent. The appellant filed its objection to the constitution of the arbitral tribunal on 12/9/2000. So this is much prior to the amendment, my lord, admittedly. The appellant herein also challenged its jurisdiction by filing an application under section 13 of the 1996 Act. The arbitral tribunal, by an order dated 2/2/2001, rejected the said application. Aggrieved thereby, the appellant herein filed a writ petition before the Honorable High Court, which came to be dismissed by an order dated 24/1/2017, with liberty to the appellant to raise objections before the appropriate forum. Now, my lord, kindly take 7. Subsequently, the appellant filed the present application before the High Court under section 14, read with section 11 and 15. So, my lord, he is applying for de jure de facto fresh appointment, substitution appointment. Didn't take any chance. Put in all the sections. Now, my lord, kindly sees. Seeking termination of the mandate of originally constituted arbitral tribunal comprising of the officers of the respondent and for appointment of a new arbitrator. Before the High Court, the appellant herein heavily relied upon section 12(5), that's the new amendment, my lord, of the Arbitration Act 1996, relying upon TRF. It was submitted on behalf of the appellant that all the 5 officers constituting the Stationery Purchase Committee, being the employees of the respondent, had rendered themselves ineligible to continue as arbitrators. It was submitted that since they had become ineligible to continue as arbitrators, they also could not appoint another arbitrator as arbitrator. It was also contended that the original members of the arbitral tribunal who initiated the proceedings had since ceased to hold their respective offices. In any case, a new arbitral tribunal had to be constituted, and therefore an impartial and independent arbitrator was required to be appointed in terms of section 11 of the Arbitration Act. Now, my lord, kindly see, before I go to the next paragraph 14, this is an arbitration which takes place, constitution is prior to amendment. Now, kindly takes paragraph 14, my lord, apropos these facts. it may be true that the early
Yes.
it may be true that the earlier arbitral tribunal stationary purchase committee was constituted as per the agreement entered into between the parties. It is also true that initially the said arbitral tribunal was constituted by the High Court in the year 2001. However, thereafter stationary purchase committee arbitral tribunal could not commence the arbitral proceedings in view of number of proceedings initiated by the appellant. There was a stay granted by the High Court from 4/5/2001 to 24/1/2017, and thereafter in the year 2019 the present application was preferred before the High Court, invoking section 14 read with section 11 and 15 of the Arbitration Act, seeking termination of the mandate of the originally constituted arbitral tribunal and to appoint a new one. Now, my lord, kindly comes to paragraph 16. As observed herein above, the arbitral tribunal stationary purchase committee consisted of officers of the respondent state. Therefore, as per amendment of 2015, subsection 5 of section 12, read with the 7th schedule, all of them have become ineligible to become arbitrators and to continue as arbitrators. Section 12 has been amended by the Amendment Act of 2015 based on the recommendations of the Law Commission, which specifically dealt with the issue of neutrality of arbitrators. To achieve the main purpose for amending the provision, namely to provide for neutrality of arbitrators, subsection 5 of section 12 lays down that notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule, he shall be ineligible to be appointed as an arbitrator. In such an eventuality, when the arbitration clause is found to be foul with the amended provision, the appointment of May I read, my lord? But if I, my lord, go through this, lordship will finally find that the Supreme Court holds that although it has been, the constitution is prior, but since there was a stay and the amendment has come into force, therefore, my lord, they are removed, being not being impartial. And that is up to, my lord, paragraph 24. Because this deals with all the judgments, then, my lord, neutrality of arbitrators, and paragraph 20, ultimately the Supreme Court holds, my lord, that this is contrary to the law as it stands now. Therefore, my lord, they have to be removed. So that is why I'm saying, my lord, here is a case where arbitration proceeding even commenced. Because lordship, my lord, I read that, my lord, proceedings were held even. There was only a stay passed by the High Court. But, my lord, in my case, I have a even better case because the commencement even had not taken place. And it's a fresh arbitral tribunal. Not a committee of arbitrators, my lord, wherein, my lord, 1 has been changed, 2 has been changed, where, my lord, I can argue. Like in the other matter, I'm arguing, my lord, that the constitution has not been made fresh. My lord, kindly see paragraph 20. In view of the above and for the reasons stated herein above, the impugned judgment and order passed by the High Court is contrary to the law laid down in TRF, Bharat Broadband, and the present decision of this court in Jaipur, Jila Dukh. It is held that the earlier arbitral tribunal, stationary purchase committee comprising of additional secretary and all, my lord, has lost its mandate by operation of law in view of section 12.5 read with 7 schedule, and a fresh arbitrator has to be appointed under the provisions of the Arbitration Act. So therefore, my lord, I will of course, my lord, show those judgments also to my lord that it has to be afresh. Here, my lord, kindly sees, my lord, my fresh appointment is 7/6/2016. And knowing this, my lord, I have filed an application which is at page 365 before the arbitral tribunal. My lord, towards the amendment,
Tuesday or Thursday. Normally this is taken up on Thursdays.
yes,
It'll run in the list. It'll run in the list.
2 PM fix করি।
না time fix করে।
Mr. Banerjee,
এই তো এই দুটোই।
Mr. Banerjee, our learned counsel, appearing for the respondent,
ও আচ্ছা আচ্ছা।
resumes his argument but does not conclude. Paragraph, let the matter retain its position in the list.
But may it be, Lordship will fix a time so that we can finish it off this side of the vacation.
Your matter is the number 2, effectively number 2 for,
Very well.
for hearing. Fixing
I
a
think,
time
my lord, it's
makes life very difficult for us.
no, I am saying, my lord, I think it is little, my lord, it is little something which, my lord, pricks the conscience, my lord, that if something has begun already, that has to be undone and a fresh, my lord, situation starts off with this appointment. But, my lord, the law has been set like that.
The point is that if 21 says, it's a statute says, when arbitration commences,
Yes.
can any court say contrary to that?
No, my lord, here the courts have held, if your lordship sees, that there is no commencement in the eye of law. There is no commencement. That's, my lord, that's, my lord.
Statute says it is what is then in the eye
No,
of what?
my lord, there is a
Section
fresh,
20.
no, my lord, kindly sees, my lord, there is a fresh amendment. There is a fresh appointment. So if there is a fresh appointment, then, my lord,
Forget
obviously.
about your case.
No, in other cases. Well, I'll show those judgments, my lord. I'll show it. That's, my lord, the procedure held. That the language used, my lord, will be startled, is that the language used is the original procedure has to be followed. Original procedure.
As you said, we might require a cup of coffee.
Grateful, my lord. Grateful.